Back to Lord.
Yes.
So I beg to mention item number 9.
Yes.
This item may kindly the past for the day only.
Okay. After the vacation?
No, yeah, for tomorrow, Monday.
Monday. Okay. Motion matter. Monday is possible. Okay. On a prayer made on behalf of the petitioner, matter is adjourned to be listed next week. Next week.
Hello, with your lordship indulgence, I would like to mention item 61 supplement.
Yes.
Lord, can it be taken at 2 p.m.? So
61.
yesterday's matter.
Okay. You are supposed to give a
Yes.
2 p.m. This we are probably sitting at slightly late. 2:30 there's a VC also, I think, no? In the second half.
Well,
first item in the second half.
Obliged.
After the judgment.
Well.
Okay.
My please, Lord. Item number 5, I have filed an affidavit in opposition on behalf of respondent number 1.
Bring it.
That may be taken, and kindly matter may be taken up after taking.
Okay, then it may not be possible today. Bring it. Try to bring it first. Okay. Yes, Mr. Arora.
Like to mention for listing of a domestic appeal, man.
Fresh matter.
Fresh matter, man.
When did you file?
The file, my lord, 25/4/24.
When do you want?
Wednesday, man.
Okay.
Mark of that.
May I please?
Yes.
Your Lordship, I beg to mention for listing of a matter that is CRP of 37 of
2018.
Yes, sir.
Next week it will not be possible. Because
Why
motion
not take it
matters.
after vacation?
Okay. After the vacation. Give a date.
Wait, please. Take for listing of a CRP IO for Monday, your lord.
Are you for fresh matter?
Fresh matter, your lord. The
Okay.
connected
Monday, when did you file?
yesterday, your lord.
Okay, Monday it will be listed. Tomorrow.
The connected matter has been listed on Monday.
Okay, just a minute. Kaile khula nahi office? Kaile office khula nahi? Monday difficult, but try.
Yes, sir.
Okay.
Hello.
Tomorrow is non-working day, but try. Okay.
Mario, also I beg to mention the matter MSc appeal. Can it be taken on Wednesday?
Fresh matter.
No, Lordship. It's filed on January 2023, Lordship. Last posted on January 2023.
Next week it will not be possible. You have it immediately after the vacation.
Lordship, a date immediately after vacation.
Yes, you give a date. You give 17th. 17th of July.
Obliged, Lord.
CRP IO, fresh matter.
When?
If possible, Monday.
Monday may not be possible. Try. No
Yes.
problem. Monday or whenever.
Yes. My lord, I would like to mention miscellaneous first appeal. It's of 2019 matter, and my lord, the matter has not been put up since.
When do you want?
My lord, next week,
Next week, not possible. Give a date after the vacation.
16 July,
Not 16th, either 17th or 19th July.
17 July.
Yes.
Month of place.
My lord, I beg to mention one matter appeal. If possible, my lord, 28th, my lord, maybe.
Matter appeal, fresh matter.
Fresh matter.
Fresh matter we can have. When did you file?
My lord, there is a condemnation petition.
And that matter, notice has been issued.
Yes, madam.
Then it's not a fresh matter.
Then, my lord, on 28th.
The other side has entered appearance.
Not.
Then what do you gain? We can have it on Wednesday. Give it on Wednesday. We'll try.
Witness.
Okay.
Obliged.
Lordship, item number 54,
54.
55,
Hmm.
56, and for that
Which item? 54, 55, 56.
56.
3 matters. Huh?
hearing.
Hearing matter. These are all matters, madam. Why are you seeking adjournment?
My senior notable
Who is your senior?
M. Islam. Respondent number
I'm
1.
Islam. Have you informed the other side? Have you informed the other? Mr. Goswami, are you there in these matters? Informed or not?
As informed that
Okay.
he is out of state.
16 matters, 1 day accommodation will give, maybe after the vacation immediately.
Your Lordship, I appear for in matters 55 and 56.
Yes. We'll have it on the after the reopening. Okay.
That may be.
Oh.
Lord.
You are praying for adjournment, fixing a date also of 16. Only because the 16 matters will fix it. Otherwise, we don't fix dates after adjournment, which has been done at the behest of a party. Okay. Prayer for adjournment has been made on behalf of
M.
Sri M. N. Islam.
M. Islam. Respondent number
M. Islam, M. Islam, Learned Council appearing for the respondent numbers 2 and 4.
1.
1. Oh, MEC, okay. There are two MEC, okay.
Respondent 5 and.
For respondent, you are the owner or what? He's for the
Respondent number
owner.
1.
Who is he? Owner or driver?
He must be claiming, Ramsey, these are all here.
Claimants.
They have to the
One,
claimant.
these are claiming.
Claimant.
For the claimants. Full stop. Considering that this appeals are of the year 2016, a short accommodation is granted directing listing of these matters on 16th of July. 16th of July for hearing. Okay.
May I please, your lord? Lordship, with the transfer petition, my lord. My marriage was solemnized in Hailakandi district, my lordship. There were two cases of pending, 125 proceedings and domestic violence act, my lord.
Just a minute, please. Petitioner is the second party
Yes, my lord.
in a divorce proceeding.
Yes, my lord. In the divorce proceeding, second part of it. He has filed two petitions also. One, 125
Just a minute, just a divorce proceeding has been instituted where?
in Karimganj district, my lord.
You have any issue?
My lord.
Any issues?
Yes, my lordship. After marriage, my lordship, I have been arrested now, posted of from the matrimony.
Issues, children. Do you have any children or not?
No, my lordship, as per
You do not know. That is what you prepare yourself in the transfer
sir.
petition. Where is the marriage?
Marriage was
solemnized?
solemnized in Hailakandi district.
Parties are Hindus. Parties are Hindus.
Yes, my lord.
Religion, Hindu marriage.
Yes, my lord.
Marriage at?
At Hailakandi district, paragraph 2 of the petition, it is mentioned, my lord, of the divorce proceeding.
And where are you staying now?
Hailakandi, in my parental house.
You want a transfer from Karimganj to Hailakandi?
Yes, my lord.
What is the distance?
My lordship,
Dis-
distance, adjacent district, my lord.
Distance.
Distance is almost 40 kilometers from Karimganj to Hailakandi.
40 kilometers you cannot travel.
Lordship, other proceedings are
Now, how far is the court?
already the respondent has entered his appearance, my lordship.
What proceeding?
In two proceeding, my lordship. In
At Hailakandi.
Hailakandi.
What kind of
DV
proceeding?
case number 87 of
DV case.
Yes, my lord.
One is DV case.
A DV case number 87 of 2022.
One is DV case. The other one?
Another is MR case number 83 of 2000.
MR case means?
My lordship, it's a proceeding under section 125 CRP.
For maintenance.
Maintenance. He has already entered appearance and it is, both the cases are in evidential stage. my lord.
How far is the district court from your parental home at
From-
Hailakandi?
My lordship, from Hailakandi town to Karimganj, it is almost,
No, you are staying at Hailakandi.
yes, my lord.
How far is the district court at Hailakandi from your parental home?
My lord, in the, my house is in town, my lordship, and district court is also in town.
How far is the distance?
Almost 2 kilometers, my lord.
2 kilometers.
Yes, ma'am. It is, her address is Hailakandi town, ward number 8, and district code is Hartalan
See,
town.
these proceedings which you have instituted at Hailakandi are before a different authority, not before the district judge. It's before the magistrate, correct?
Yes.
And the divorce proceedings is before a district judge.
Yes.
Even if it is transferred, it will not be before the same authority.
My lord, it's the same. The marriage also solemnized in Hailakandi district, my lordship, and I have not receiving any maintenance, my lordship. It will be-
Maintenance is a different aspect.
my
You have
lordship,
already
I am
filed a
not,
case.
Employed also and going there. And
You do not know whether you have any children or not. What does your husband do? Do not know. How much is his income? What do you do?
I'm unemployed, my lord.
What is your qualification? Sir, Laskar, don't come like this. Come prepared, not like this. Come on Monday. Come prepared. On the prayer made on behalf of the petitioner. Matter is adjourned to be listed on Monday next.
Hello.
Item 2. Mr. Dr. Sharma, what is this?
Must be a promulgation order passed by the district judge acting as the chairman of the education tribunal.
Okay,
Sonitpur, Your Lordship.
okay.
Our petition was dismissed, Your Lordship, for non-prosecution. That order is at case 97.
For non-prosecution.
Non-prosecution, Your Lordship.
Then you had filed for restoration.
Yes.
That has also been
No,
dismissed.
that could not be filed, Your Lordship. The learned district judge who was
This
the chairman of the
education tribunal of which district?
Sonitpur, Your Lordship. Actually, what happened, Your Lordship, ours is a school established in 1989.
No, we are not going into the merits. You are aggrieved by the order by which your matter has been dismissed
Yes, yes.
for default. Thereafter, what did you do?
Thereafter, could not be done anything. We wanted to file a restoration petition. The learned court below said that you go to the High Court.
Where is the order?
No order has been passed on verbal here.
No, where is your statement? Yes, madam, you're for the education department. Yes, isn't there any provision for restoring?
Yes, Lordship,
It can be restored, Your Lord.
And why don't you apply for restoring? Then if it's dismissed or rejected, you come before this court.
If Your Lordship passes an order like that,
We will
That will-
pass,
that will also
but
suffice.
first we'll have to be convinced that whether there is a power to restore. If the tribunal says that we don't even have the power, then matter will be different. It will be a futile exercise sending you back. Where is the act?
I have to say that, Your Lordship, I am unable to trace the brief Lordship.
Dr. Sharma, you have the act, tribunal act.
After some time, Lordship, I will.
You come with,
After some time,
at
Lordship.
least you should come with the act, Mr. Dr. Sharma. After some time. Education Tribunal Act এখন আছে নেকি? হেৰিত আছে নেকি? এখন education. Manual 11 হৈছে তো থাকিব পাৰে নাথাকিব পাৰে। এই তলৰ এইখন আছে। তলখন চাই ল'বাচোন আছে নাই বেলেগ মেটাৰ মই লৈ থাকোঁ তেতিয়ালৈ এই ইণ্ডেক্সত চলি
Me, please, Your Lordship. Here, Your Lordship, I am challenging the entire proceeding in which the learned session judge Dibrugarh has taken cognizance and framed charges against me under the Assam Land Grabbing Act. So, Your Lordship, here I have come.
You can come in a revision period, civil revision.
Yes, Your Lordship. There is a provision for appeal but the special tribunal has not been constituted. So therefore, under such
No, no,
circum-
no, revision is not the problem. You
Yes.
come under as a civil revision or criminal revision.
Civil revision.
Is it a civil proceeding?
These are mixed, both civil and criminal.
No,
Because-
normally what is done?
Normally civil revision, because
Civil
there are
revision.
two cases also,
Okay.
which I brought your lordship. So
Yes, what is it? Order is 9-1.
9 months, which is at page 42.
Please read.
Uh,
Who are you?
I am the alleged land grabber.
Second party.
Yes.
Okay,
Uh,
then what had happened?
I'll read from paragraph 5 at page 42. Record reveals that by order dated 30/11/2019, this court has found that allegation made in application attracts ingredients of land grabber and land grabbing as provided under 2D and E of the Act. Accordingly, by order dated 30/11/2019, cognizance of criminal offence under Section 3(1) of the Act was taken.
Show us some law that it's a civil revision.
So, Lordship, first I'll show that this is entirely a civil dispute and not a land grabbing.
No, that's a different, that will go under merits facts of the case. We are only asking you a
yes.
question whether an order by the special judge
Yes.
who has to be a session judge, and this offense is said to be sessions tribal. And thereafter, how a civil revision is maintainable?
Because, your lordship, this is an order, and first it is the duty of the session judge to decide the
No,
civil.
why can't you file a criminal revision?
Because, your lordship, I have two cases also, which was earlier decided by the
Let us see. A civil revision.
yes, civil revision.
So,
Here, your lordship, second paragraph. This revision petition is filed under 227 of the Constitution, invoking supervisory jurisdiction of High Court for quashing and setting aside the impugn order dated 5/1/22, passed by the learned special judge Sonitpur Tezpur, whereby the petition filed by the petitioners for keeping in abeyance the land grabbing case number.
okay, you have structured under 227.
Yes.
Okay.
So here I'd like to rely on paragraph 25
Of?
this judgment.
No, that is okay. 227 is okay. Now we'll come to the facts.
Here what had happened, I have come into possession of land measuring 14 bigha, 10 lesser, as Khatiyandar under 1T state. And that Khatiyar, your lordship will find at page 23.
No, only charge has
Yeah.
been framed.
Charges have been framed,
You are
And,
aggrieved by framing of charges.
framing of charges, and also taking cognizance against me without determining the civil liability. The civil liability now, as per this Khatiyar, we are in continuous possession since the year 1977. Now, this particular document has not been given any credibility by
Which
the
document?
this Khatiyar, which
Page-
I have annexed at page 23.
No, this will be one of your defense.
That will be by defense.
Did
but,
you pray for discharge?
there is no provision for discharge.
if-
Like
The charges have been framed. You have a defense, valid defense. You can cite this defense
therefore, your lordship, I am relying at that paragraph 25
of
this
this
judgment.
judgment.
Yes, Jainal Abedin.
Yes. What is there?
May I read your lordship? Paragraph
Yes.
25.
Yes.
From the above section, it is seen that in the first phase, the tribunal is required to decide the civil liability. And once the civil liability is decided, the tribunal finds that allegation of land grabbing is established prima facie. The tribunal may proceed to the second phase of criminal liability and try the offences after framing charge under the penal provision provided under Section 4(2) or 5 of the Assam Land Grabbing Act 2010, as the case may be. Now, in the present case, a civil liability which was determined, that was wrongly determined by the court below.
Why?
Without considering this Khatyan and the revenue receipts that I have been paying.
Was
The
it placed before the court, tribunal, court?
that I'm not sure, Your Lordship, but
If you have not placed it, how can you attribute fault? You place it, it has been rejected or ignored or not appreciated, matter is different.
but
Where is
the
your,
petitioner there had placed one Jamabandi, and in the Jamabandi, his name was there in the Patta. So as a Pattadar, the court decided that civil liability has been decided against me.
we can
So-
issue notice at best. I don't think we have a case. Heard 3 as Dr. Learned Counsel for the petitioners who by means of this petition filed under Article 227 of the Constitution of India has put to challenge an order dated 9/1/2024 passed by the Additional Session Judge Dibrugarh in Miss land grabbing case number 4 of 2017. By the aforesaid order, comma, the charges have been framed against the petitioners. Full stop. It is submitted that such action has been taken without coming to a finding on the civil liability. Full stop. That notice be issued, returnable by 6 weeks. Let steps be taken for service of notice, sole respondent, registered posted ADs. Steps within 3 working days.
Obliged.
You take this back.
Mayor, please. Lordship,
Yes.
Lordship, here this petition is filed for setting aside the ex parte order and subsequent to all of its order, including erroneous judgment and decree. Lordship. The interim order, which I have challenged, is at page number 23.
Your petitioner is what? It's a suit. This cases are arising out of a suit.
Out of a suit.
You are what? Plaintiff?
I was the defendant.
Defendant? Defendant.
original
Suit
suit.
for?
Suit was filed by the respondent
Suit for?
declaration
Declaration.
of right title and interest.
Hmm. Okay, then what happened?
Then Lordship, I entered into appearance. Thereafter, suit was proceeded against me as party.
You did not contest the suit.
And I am debarred from contesting the suit. I am challenging that order on which I am declared as ex party. It is at page number 23. So
23.
23.
You filed order 9 rule 13.
In the meantime, I have lost the contact with the learned council, and I am not ever
Page.
page 23.
23. Eighteen 6/22.
22. There 2 sets of order was passed on that day. First part is that the court is adjourned in view of unprecedented flood in Dorong district today, for which normal life is affected. 6 for WS by defendant number 1. I was the defendant number 1. And the same day, another order was passed, whereby I have been deferring for contesting the suit.
Thereafter, this is of 2022. Thereafter, what happened?
Thereafter, I have immediately lost my contact with her. I was not aware about
This order. This order.
this order as well as judgment and decree.
Judgment and decree has also been passed.
Also been passed.
Where?
Judgment and decree at page number 24 onward. 24 onwards,
Ex parte judgment,
ex parte judgments,
4/4/2023.
23,
No, this is of 3rd May
30.
24.
And now, Lordship, the execution proceeding also been going on. Only final decree is to be left. Passing of final decree is only had to be overheard.
Final decree means this was the
And
final
the
decree.
only payment of cost is remained.
Now you're challenging what?
I am challenging that. First, I am challenging the ex parte order, which was and subsequent to all of this judgment and decree also.
In a revision.
Yes, Lordship.
How?
227.
No, how? 227 powers can be invoked. You cannot file an appeal.
I appeal. I have already been. I am challenging ex parte order.
Ex parte
So-
order also you can challenge.
Excellent. But now the proceeding, execution proceeding is going
You have
on.
to file an
Nothing has
appeal.
been-
You did not file for vacating ex parte.
Okay.
You did not file for vacating ex parte.
Yeah.
Now you have to challenge the decree in accordance with law. How can you file a 227? Code prescribes for an appeal. You prefer an appeal, it may be delayed. You file application for condonation of delay.
Of course.
That you know what to do. How do you invoke 227? When the code itself gives you a remedy. You prefer an appeal before the appropriate court.
Appropriate court means this court also only.
This is not this court. This is not the appellate court, first appellate court.
No,
Cannot be.
Order is passed by civil judge, senior division 1.
If it's an if this court is the first appellate
First.
court, you prefer an appeal, cannot be a revision. Prefer an appeal will allow you to the certified copy to be returned also. Otherwise also you are barred by time limitation. You have to file application for condonation. Honorable Supreme Court has been continuously in Birudnagar, it's been this practice has been deprecated. When the code prescribes for a remedy, you cannot take recourse to 227. We dismiss this, giving you liberty to file appeal. Heard. Sri Bifukan, Learned Counsel, for the petitioner who has filed this petition under Article 227 of the Constitution of India, read with Section 151 of the CPC, against an order dated 18/6/2022 and all subsequent orders, including judgment dated 3/5/2023, passed by the learned civil judge, Senior Division, Mangaldoy, in connection with in title suit number 46 of 2021. Full stop. The petitioner is the defendant in the suit which was instituted for declaration of right, title, and interest. Full stop. Para, it is submitted that wide the order dated 18/6/2022, comma, the suit was proceeded ex parte and subsequently wide the judgment dated 3/5/2023, the suit has been decreed in favor of the plaintiff. Full stop. It is also submitted that title execution case number 2 of 2023 has been instituted, and only then
Only
the
final decree.
petitioner would come to know about the proceeding, as the council did not inform anything. Full stop. Para. Be that as it may, comma, the orders and the orders culminating in the judgment which are sought to be challenged by way of this petition under Article 227 are appealable orders under the code COD, C capital, full stop, para. When, para no. When such provision of appeal is provided in the code itself, comma, the powers under Article 227 cannot be invoked, full stop, para. The Honorable Supreme Court in the case of Birudnagar has laid down as follows. Take a sir, William. The petition is accordingly dismissed as not maintainable. Full stop. However, liberty is granted to the petitioner to prefer appeal if so advised. Full stop. On the request of the learned counsel, comma, registry is also directed to return the certified copy of the impugned order. I dismiss in view. Okay, next. Yes, your affidavit has come.
May I
Okay,
please, your
Mr.
lordship?
Sharma, what is this?
The petitioner before this honorable court, as the plaintiff filed a title suit number 49/2021.
This is under 227.
Yes, sir.
The petitioner is the
Plaintiff in title suit number 49.
plaintiff. Suit for
Who sued for specific performance of contract. And that suit was filed by the present petitioner against the present performer exponent numbers 8 to 20.
against pro forma
Exponent numbers 8 to 20.
8 to 20. Okay,
That was suit for specific performance of contract.
okay.
And suit was filed before the learned civil judge senior division number 2, Guwahati.
Okay,
And title suit number 49, that suit was decreed on compromise on 7/2/2020. 7/2/2020.
decreed.
Decreed on compromise.
Okay,
Hereafter, Your Honor, as per the terms of the compromise decree, the performer exponent numbers 8 to 22, 8 to 20, that is the defendants in title suit number 49 of 2021, they have executed the registered sale deed number 9357/2022 in my favor.
9.
9357/2020.
9357.
/2020. Dated 38/4/2020.
That is the registered deed.
Yes.
9357 of 2022.
Yes.
Registered deed.
Yes.
Sale deed
Registered sale deed.
by those pro forma respondent
Performer exponent numbers, present performer exponent numbers 8 to 20
in favor of the plaintiff petitioner.
in favor of the petitioner. The performer exponent present performer exponent numbers 8 to 20, they were the defendants in the title suit number 49/2020. Thereafter, Your Honor, the present respondent number 1,
Yes.
he filed an application under order 22/21, rule 99/100/101.
Who has filed? The
The
present?
present respondent, present
Okay,
respondent,
R1.
Yes.
Filed order 21 rule 99
99.
and 101.
Yes. 100 and 101.
Okay,
99, 100 and 100.
yes.
And that was registered as Mizde case number 751/2020.
Ms. J 751
751/2020.
20. Okay,
2022.
2022,
and that was filed before the same court.
correct?
During pendency of the Misde case number 751, Lordship,
Hmm.
the title suit number 37 was filed by the present respondent number 1, Your Honor,
Huh.
along with the respondent number 227.
37, another separate suit.
Yes.
37 of
37 of 2020
by R1 along with other.
by R1 and R227.
What is the subject matter in this?
Same subject.
Okay.
Hereafter, the present petitioner, who is the decree holder in title suit number 49 of the 2021, that he has filed an application under Order 7, Rule 11D of the CPC for rejection of the plaint that separate suit is not maintainable.
You
And-
filed 711.
Yes, and that petition was numbered as petition number 1338 of the 2020.
13?
1338 2023 dated 10/4/2023.
10/4/2023.
Yes, sir.
Okay, you filed petition.
And after filing that suit, filing that petition under Order 7, Rule 11, the Misde case number 751, that is filed under Order 21, Rule 99, 100 and 101, that was withdrawn by the present respondent number 1. That petition was withdrawn on 31/7/2023.
Hmm.
The subject matter of all the proceedings, as I have mentioned before, this honorable court, are same. Thereafter, after hearing both the parties' lordship, my application under Order 7, Rule 11D, that was rejected by impugned order dated 27/5/2020.
27/5/2024,
27/5/2020.
rejected.
That was the impugned order before this.
1338 of 23 has been rejected.
Rejected. Dated 10/4/2023. That was rejected by impugned order dated
27/5/2024.
Yes. Kindly see the plaint of title suit number 49, annexure 1, page 18.
Now that is okay. Now what is the what is,
Impugned order.
now what is your ground? What are your grounds?
So, admittedly, Lordship, after the compromise decree was passed, there is no separate execution proceeding under Order 21, Rule 10. And that was the main ground for rejection of my petition under Order 7, Rule 11, saying that because there is no independent execution proceeding pending before the executing court, so the petition under Order 21, Rule 99, 99, 100 and 101 cannot be filed. That's because there is no independent execution proceeding after the compromise. Kindly see the impugned order.
Yes.
So my humble submission is that the Order 21, Rule 101, Lordship,
Yes.
questions to be determined.
Hmm.
All questions, including questions relating to right title or interest in the property,
Hmm.
arising between the parties to a proceeding on an application under Rule 97 or Rule 99 or their representative, and relevant to the adjudication of the application shall be determined
Hmm.
by the court dealing with the application and not by a separate.
Yes.
And for this purpose, the court shall notwithstanding anything to the contrary contained in any other law for a time being enforced, be deemed to have jurisdiction to decide such case.
Yes.
So my humble submission is that the title suit number 37/2023, which was filed subsequent to the passing of the decree, that is not maintainable, as because that is the bar under Order 21 Rule 101, as because no separate suit cannot be allowed to file. So if
Rule 101 has to be read with 97 and 99.
yes, Lord.
97 and 99 presupposes that a
Yes.
decree holder has put the decree to execution
Yes.
by which a third party is affected.
Yes,
Third party is not
That is the-
supposed, third party is not supposed to, is not required to file a separate suit. He can approach the executing court, same court, with an application
under Order 20.
and only then he is not required to file a separate suit. Now here, there was no execution proceeding.
Yes, sir. So that is the ground for rejection of a petition under Order 7 Rule 11. My humble submission is that as because
No, you cannot preclude him or leave him remediless. He has the right to challenge the proceeding, whether,
by filing an application under Order 21 Rule 9,
where is the execution?
I am going on that point.
No, is there an execution?
Yes, I am on that. point.
Yes. Show us the execution case number.
There is an authority of they had already filed an application initially, Lordship, an application under Order 21 Rule 97, as I have already mentioned. That was, although that was filed by the present respondent number 1, but in that petition, it was specifically stated that he had filed the application for himself and for protection of other other co-owners.
Okay,
That was-
mistaken application will not give you any right.
Yes.
First, you have to show there is an existence of an execution proceeding.
There is
Person
no,
to-
yes, there is no execution.
Then
proceeding.
in
I am
that
on that,
case-
I am on that, Lordship.
দেখা। AC টো অলপ বন্ধ কৰি দিয়ক না, পিছত দিব। Yes, please.
2004 AIR Calcutta 74 plot. Similar was the situation.
2004,
2004 AIR Calcutta 74.
Minoti Ghosh.
Minute.
Yes.
Kindly see paragraph number. The revisional application under section 1.
Pera.
First paragraph. First. The revisional application under section 115 of CPC is directed against the order dated 22/7/2002 passed in Miss case number 44.
Show us that part, that execution case is not there still then
11 paragraph is 9.
9. Yes.
This provision stipulates two things.
Hmm.
First, all questions, including questions relating to right title or interest in the property arising between the parties to a proceeding on an application under Rule 99 shall be determined by the court, and secondly, not by a separate suit for the purpose of determination of such question. Again, under Order 21 Rule 103, any adjudication made by the court on such application under Order 21 Rule 99 by deciding such questions is appealable as if such adjudication was a decree. These provisions, therefore, is no uncertain terms give an impression that the proceeding that could be followed in an application under Order 21 Rule 99 of the Code is in the nature of a proceeding of a suit, and in practice, the proceeding of a suit as far as possible are adopted in adjudication of such application. It is therefore clear that an application under Order 21, Rule 99 of the Code cannot be said have no independent existence without any execution proceeding being in existence. Therefore, the contention that such application cannot be entertained unless there is an execution proceeding pending cannot be sustained in law. On the other hand, the proceeding on the basis of the above application under Order 21, Rule 99 of the Code being in nature of a suit, the plea that the facts and circumstances of the case, the opposite parties, numbers 1 and 2, or to have filed an independent suit, appears to have been set. So, similar is the situation. There is no independent execution proceeding filed by the present petitioner against the compromise decree.
See, we cannot just read 101. 101 is subject to 97 and 99. 97 is a different provision where resistance is given to a decree holder or a purchaser of a property in auction. And 99 is the third party right. Come to 99.
Yes, Lordship. The outcome of the compromise decree was the registered deed of sale.
Yes.
And that registered was, amongst other relief, my registered deed was challenged in title suit number 37.
That can be done. Why not? And read 99. The Honorable Calcutta High Court with greatest of respect has just quoted 101 without even going to the aspect of 97 and 99. 97 is not applicable. It is not a resistance to the decree holder or purchaser property in a auction. It is the only applicable is 99. Kindly read 99.
Where any person other than the judgment debtor is dispossessed, they are
Yes.
the third party.
Third party, they are like them, yes.
Dispossessed of immovable property by holder of a decree for the possession of such property, which such property has been sold in execution of a decree by the purchaser thereof, he may make an application to the court complaining of such dispossession.
Yes.
Where any such application is made, the court shall proceed to adjudicate upon the application in accordance with the provision herein contained.
Yes,
That is
where-
101.
Yes.
That is subsequent 101.
Yes, 101 is dependent upon 29 and 97.
Yes.
97 is out of the context. 99 is the only provision where under 101 you need not file a separate
Yes,
suit. Now 99 to be applicable, a decree has to be executed, put in execution, and at that time a third party is dispossessed. He is not required to file a separate
for
suit.
which the relief, for declaration of right and interest, cancellation of my registered deed, they have sought for relief of recovery of poison.
They can, whatever they can. That's a different matter. That's not been adjudicated.
So
You
for
have,
adjudication of the
you have all
dispute-
the rights to
for
file
adjudication
your
of-
defense. Say that they are
for
not entitled to
adjudication
the
of the
release.
dispute, Lordship, for adjudication of the
But
dispute,
711 will not lie because the very initiation of an order 21 rule 101 petition was not even maintainable.
it's because they are
And even otherwise, if they have withdrawn this. You cannot preclude them for challenging the registered sale
I am
deeds.
not that, Your Honor. I am on the point that they have filed a separate suit in spite of filing an application under Order 21, Rule 99.
Now the suit, now,
101.
yes, for that, the suit will not be maintainable now, even now, after
Yes.
withdrawal of the application.
That was filed by the present respondent number 1 only. All the parties were
Now,
not ready.
order 21, rule 99, 97, 19, 101 is not maintainable. They filed, it's been withdrawn. It's been withdrawn.
Yes,
Now, can they be left remediless?
they ought to have filed application. Yes,
Remediless?
at
We will not agree with you.
the present time also they can file an application under Order 21. Lordship.
Where is the decree for execution?
The authority, as I have.
No, that has not even considered 99. Simply quoting 101 without going on 99, that we don't think.
Similar was the situation, Lordship.
No, we don't
Similar
think.
was the situation. As because there is no
At
execution
best, this
of-
will have persuasive value, Mr. Sharma, you know. We'll go by the law. We'll go by the code. What is there in the code? Code says 101 is dependent upon 99 and 97. 97 is for a different purpose. 99 is for different purpose. 99 could have been applicable had there been any execution proceeding. And in any case, they've withdrawn it.
I'm not on the earlier application on the order 21. I am on title suit 37, Lordship.
Yes, 37.
37, my humble supposition is that 37 is not maintainable as because they have no right to file a separate suit. They ought to have filed an application under order 21. Rule 19.
What is the language employed in 101? Let us again read.
Yes, Lord. All questions
Yes. All questions, including questions
questions
related to so and so, arising between the parties to a proceeding on an application under 97 or 99.
Yes, Lord.
The expression is or.
Yes.
It may be 97, it can be 99. 97 is out of the context. 99 maybe could have been applicable had there
99
been
is
an
applicable.
had there been an execution proceeding.
But Honorable Calcutta High Court says that
We
there
have already
there is
expressed
no,
what we
no
want.
requirement for an independent execution proceeding, Lord. The decree is itself sufficient.
Sorry. Yes, heard Sri R. Sharma, learned counsel for the petitioner. Also heard Sri T. Ali, R. Ali, learned counsel for the respondent number
1 to 7.
1 to 7. Full stop para. By the present application under, please have your seat, under Article 227 of the Constitution of India, the petitioner has put to challenge an order dated 27/5/2024 passed by the learned civil judge, Senior Division number 2, Kamrup M, in title suit number 37 of 2023, full stop, by the impugned order, comma, the petition number 1338 of 2023, which was filed by the petitioner under Order 7, Rule 11 of the CPC, has been rejected. Full stop. Para. A brief, a narration of the brief history of the case would be beneficial. Full stop. Para. The petitioner, as plaintiff, had instituted title suit 49 of 2022 for specific performance against 2021 for specific performance against the pro forma respondent numbers 8 to 20 who were the defendants. Full stop. Wide on 7 to 2020, 2021 compromise decree 2022. 7 to
2022.
22. On 7 to 2022, comma. The aforesaid suit had culminated in a compromise. Full stop. It is contended that in terms of the said compromise decree, comma, sale deed number 9357 of 2022 was executed by the pro forma respondent 8 to 20 in favor of the petitioner. Full stop. The respondent number 1 herein had thereafter filed an application under Order 21, Rules 99, 100 and 101, which was registered as Miss J 751 of 2022. Full stop. Subsequently, comma, on the same subject matter, comma, the respondent number 1, along with the respondent numbers 2 to 7, had instituted title suit 37 of 2023. Full stop. Para. The petitioner accordingly had filed a petition under Order 7, Rule 11 of the CPC, which was numbered as 1338 of 2023, and vide the impugned order dated 27/5/2024, comma, the said petition has been rejected. Full stop. Para. Sri Sharma, the learned counsel has submitted that the subsequent title suit 37 of 2023, which was admittedly instituted during the pendency of the petition under Order 21, Rules 99, 100, and 101, was not maintainable in law. Full stop. It is submitted that under Order 21, Rule 101, comma, all such applications filed under Rule 97, all or Rule 99 are to be adjudicated by the court and not by a separate suit. Full stop. He submits that there being expressed bar in the code itself, comma, the application under Order 7, Rule 11 of the CPC ought to have been allowed, and this aspect was not appreciated by the learned court below. Full stop. The learned counsel has, however, fairly informed that after filing of the petition under Order 7, Rule 11 on 11/4/2023, no, which was done on 11/4/2023, comma, the respondent number 1 herein had withdrew the petition number 751 of 2022 on 31/7/2023. Full stop. The learned counsel, however, submits that by such withdrawal, comma, the defect in law cannot be rectified. Full stop. Para. In support of his submission, comma, the learned counsel has relied upon a decision of the Honorable Calcutta High Court reported in AIR 2004, Calcutta 74, naam de dipa, huh? In the said case, comma, it has been held that existence of an application under Order 21, Rule 99 can be existence colon, okay? No, that an application under Order 21, Rule 99 of the Code does not require existence of an execution proceeding, and the same can independently exist. Full stop. Para. Per contra, comma, Sri Ali, the learned counsel for the respondent, has submitted that the MISJ 751 of 2022, though filed, was done on a wrong conception of the law. Full stop. In any case, comma, it is submitted that such application was not maintainable, would not have been maintainable in law in absence of any execution proceeding qua the decree dated 7/2/2022 passed in TS 49 of 2021. Full stop. The learned counsel further submits that the said MISJ case 751 of 2022 was withdrawn on 31/7/2023, and therefore there is otherwise also no impediment in law for filing the suit and its continuation. Full stop. Para. The rival contentions have been duly considered. Full stop. Para. The provision of Order 21, Rule 101 is intrinsically connected with the rules 97 and 99 of the same Order 21. Full stop. While Rule 97 is on the aspect of resistance to a decree holder or a purchaser of any such property sold in execution, comma, Rule 99 is in connection with obstructions, is connection with disposition of any person other than the judgment debtor in the execution of a decree. Full stop. While, and in the instant case, comma, it is Rule 99 of Order 21, which would be applicable in connection with the application made. Full stop. The aforesaid Rule 99 clearly lays down that the application may be filed by any person other than the judgment debtors in case of disposition of immovable property by the holder of a decree, or where such property has been sold in execution of a decree. Full stop. The aforesaid provisions make it clear that to determine the questions which would arise under the provision of Rule 101 by the same court and not by a separate suit would require disposition of a third party of immovable property or buyer of such property which has been sold in execution of a decree. Full stop. Therefore, comma, when admittedly the decree qua Title Suit 49 of 2021 was not put to execution, comma, this court is of the considered view as to whether considered view that such an application may not even be maintainable. Full stop. In any case, comma, the without even going to the aspect of maintainability of Miss J case 751 of 2022, comma, it transpires that the said application was withdrawn on 31/7/2023. Full stop. Though it is a matter of fact that Title Suit 37 of 2023 was instituted prior to such withdrawal, comma, a party cannot be left remediless and in any case cannot be precluded from filing a suit for espousing his grievance. Full stop. The petitioner, who is the defendant in the present suit, will have all the rights to make his defense and resist the suit. Full stop. However, to exercise the powers of Order 7, Rule 11, comma, the bar in law has to be an explicit one which can be perceived without even going to any other matter and only from reading of the plaint. Full stop. Para. The Honorable Calcutta High Court, now apart from the fact that the judgment of the Honorable Calcutta High Court is only having persuasive value this court has noticed that while taking into consideration the provisions of Rule 101, the provisions of the connected Rule 99 was not taken into consideration. Full stop. Para. In view of the aforesaid facts and circumstances and the discussions made, this court is of the considered opinion that no case for interference is made out and the revision is accordingly dismissed. Yes. I কি আছে? There was a caveat. Horse before the cart or cart before the horse. But formality has to be done. Heard Sri R. Ali, Learned Counsel, for the caveator who has lodged this caveat in connection with an order dated 27/5/2024 past so and so likhi diba, huh? The caveator would be heard in the event this court proposes to pass any interim order. Para caveat stands the church.
Item 6.
May I please, your lordship?
Yes, yes.
Lordship, in this matter, I being the plaintiff, I instituted a suit for declaration of right, title and interest, eviction and recovery of possession.
Just a minute. Petitioner is the plaintiff.
Petitioner is the plaintiff, your lordship.
You have come under 227 or what?
Yes, your lordship.
Petitioner is the plaintiff. Suit for?
Suit for declaration of right, title, interest, eviction and recovery of possession, your lordship.
Eviction and recovery of possession.
Recovery of possession.
Okay, then what happened?
Your lordship, the defendants entered into appearance and filed their written statement along with the counterclaim.
Counterclaim also.
Counterclaim also.
Okay.
Now, they filed it on 23rd of August 2023.
Okay.
Now, I was supposed to file my written statement against the counterclaim, and the date was fixed, but I couldn't submit it on the date fixed due to medical reasons. And I submitted on the next date, but it was not accepted. And hence, I'm before this. Your
What was the time?
lordship.
The time elapsed from filing of the counterclaim
Your lordship.
till your presentation of the written statement.
Yes, your lordship. If I go,
When did you present your written statement?
I filed it on 1st February 2024.
1.
1 February 2024.
So it's beyond the time.
Beyond the time, your lordship. Your lordship, the learned court below had fixed 13/12/2023 to file my WS.
No, was it for filing next date fixed?
And after 13 December, next date is 1st February. So I filed it on the next date itself.
No, are you required to wait for the date or will you go by the prescription
your
of the
lordship,
code?
No, your lordship, the reason is that there was a petition filed by my sisters and my niece to implicate them as the plaintiff. And now I was of the bona fide belief that if the petition is allowed, then the written statement may be amended. And again, and the counterclaim may be amended.
That may not be an acceptable thing. Now, what is the stage?
The stage, your lordship, now the issues have not been framed yet. Not so I was suffering from jaundice, and that is the main reason I couldn't file on 13 December. And I took that ground, but the learned court below says that I couldn't explain the delay in
Even 13 December would be beyond time.
Yes, your lordship.
You are not supposed to wait till the date. You are supposed to file within the time prescribed in law.
Your lordship,
Who are the respondents now?
lordship, there are three respondents. They are the
Can I-
dependents.
From the same area.
Same area, your lordship.
Can you serve dusty upon them? Can you serve dusty service?
Yes, your lordship, we can do that.
Okay, we'll issue notice. We'll try to dispose this matter in their presence.
Yes, your lordship.
Your name?
A Khan.
Part 3, A Khan Learned Counsel for the petitioner, who by means of this petition under Article 227 of the Constitution of India has put to challenge the but to challenge the orders dated 13/12/2023 as well as 10/5/2024 by the learned Civil Judge Senior Division Chirang in title suit 10 of 2023. Full stop para. It is submitted that the petitioner as plaintiff had instituted the aforesaid suit wherein the defendants along with their written statement had filed counterclaim. Full stop. However, the written statement by the petitioner as plaintiff to the counterclaim could not be filed in time, and his subsequent prayers to allow him to file the same has been rejected. Full stop para. Let notice be issued returnable on. We'll give a date, Mr. Khan.
Yes, my lord.
21st. We'll have it on 17th.
17.
Okay, immediately after the vacation, 17th of July, 2024. Let steps be taken for service of notice upon the respondent by registered post with AD. Steps within 3 working days. Additionally, the petitioner is also required to take steps for dusty service upon the said respondents, which is, however, required to be routed through the registry of this court. Full stop. The registry is to specifically give the next date fixed in the notice accompanying the dusty service. And prior to the next date, the petitioner would file an affidavit in proof of such dusty service. When is the next date?
Next day is 16th of July.
16th of July. Okay. The prayer for interim order would be considered on the next date. We'll fix on 15 then. 15, but can you file the affidavit? No, on 17, on the next date. We'll not pass interim order. We'll try to dispose this of in their presence. Okay. You inform about this pendency in the court on the next date.
Yes, my lord. Obliged, the lord.
Yes.
The tribunals of I don't know, order of this honorable court.
As a paisa tate ase. Okay.
Yes.
Yes.
Case 2, your lord.
Yes. Yes.
So at page 24, your lordship, 124,
Yes.
Police Manual, your lordship.
Ase nahi so, sir. 124.
This is under Assam Education Provincialization of Service of Teachers and Reorganization of Educational Institutions Act 2017.
Yes.
At page 124, your lordship, item 19, section 19 here. Truth and proceeding.
Yes.
Here it is at clause 2, your lordship. It is only mentioned here that the grievances of provincialization would be dealt by the educational tribunals formed under this act, your lord. But there is no provision as such of any appeals for revision or whatever or restoration. Nothing is there, your lord. There being nothing in this act, your lordship, we have come for revision of this matter. There being no provision for appeal also, your lordship.
Yes, what do you say,
Yes,
madam?
lordship, the tribunal is followed CPC lordship. So, and specifically there is.
If it comes from you, then at least Dr. Sharma will have a remedy. But are you submitting on instructions?
Yes, lordship, I will produce
Now, have you got the instructions?
lordship.
Are you submitting this on instructions or are you making your submissions on your own?
No, lordship, it is on submission or instruction, lord.
We record it, but
But it is not mentioned here that will
No, that
be
is why
covered
you are
by-
making a very responsible statement. If you want some time, we can give you some
Lordship,
time.
after vacation,
Not after vacation. We'll have it on Monday or Tuesday.
Lordship,
But you opt in proper instructions,
And
okay?
Lordship.
And try to have it in written form.
Lordship.
At least a email. You should not be in difficulty tomorrow. That is our concern. Okay? Uh,
Monday, Your Lordship.
okay. Uh, while considering this matter, comma, the issue as to whether an educational tribunal would have the power to restore an application which has been dismissed on default has arisen. Full stop. Miss, your name?
Escort.
Miss Esquire, Learned Standing Council Education
Okay.
Department. Prays for and is granted time till Wednesday next to take instructions in this regard. Full stop para. Based on the said instructions, comma, this court would make an endeavor to dispose of this petition.
Of Lordship.
Item 7.
May I please, Your Lordship? Lordship, I have the petitioner as plaintiff filed two suits and filed an application before the learned court below for keeping in abeyance, in other words, staying the suit filed by him earlier, my lord, earlier one. And learned court below has rejected the petition on the ground that earlier suit cannot be stayed, my lord. In this case, my lord, what happened? The petitioner has entered into an agreement with respondent number 123
Hmm,
for selling of the suit land, my lord.
okay, then,
Later on, my lord, the respondent number 4 has entered into an agreement.
now why do you want the earlier suit to be stayed? It's your suit.
Because the suit land
Yes.
in my suit is the suit land of the suit of 2015, which was in between respondent number 1 to 3 and 4, my lord.
Where is the impugned order?
Yes, my lord. At page, my lord, 110, 110.
Now, under what provision do you pray for staying of your own?
My lord, 151, my lord. 151, my lord, there is judgment, my lord.
You pray for staying of your own suit.
Yes, my lord. Because, my lord, they have already gotten decree, and that decree makes my suit infectious, my lord. That paragraph, my lord, 21. Married, my lord.
Yes, what is this?
My lord, paragraph 21.
Paragraph 21.
21.
Here, this judgment, have you read the judgment from the beginning?
my lord.
What is the judgment? By which bench?
Division.
Not division bench. See? How many judges?
And 3 judges. my lord.
Then what had happened?
But my lord, here, paragraph,
These are all,
paragraph 1 itself, my lord.
yes.
Sitting, Hansariya there, sitting singly has referred the following question
Yes.
to the division bench, my
Yes.
lord.
Thereafter,
That whether, when section 10 is not
and
applicable.
this section 10, the point issue was raised by whom? By the defendants.
Yes, my lord.
Here you are the plaintiff.
I am the plaintiff. What has happened?
Section 10 is
Now-
section 10 is a codification of a doctrine.
Yes, my lord. Res subjudice.
10, 11, res sub judice, res judicata
Res-
are universal, are common law doctrines, only codified in the form of law.
Yes, my lord.
Otherwise also these are doctrines. Now this defense was taken by one of the defendants and said that yes, 10 is a valid ground, stay of suit. Now you are the plaintiff. Under what provision?
There is no specific
No,
provision.
if there is no specific provision,
Then 151, my lord.
no, if there is no specific provision, 151 for what?
For ends of justice.
Ends
my
of
lord.
justice by you. You had, you withdraw the suit.
My lord, because the suit length of the suit.
And you are praying for what? For staying of the earlier suit. This is, if you are praying for stay of the later suit, the matter could have been different, that chronology.
No, because, my lord, here,
Well, why both the suits cannot be heard together?
because one is a defense evidence and one has just started, my lord. Or otherwise, that can be also be done, my lord. Meaning is there by, my lord, because of that decree obtained by respondent number 4, this suit is going to be infectious, my lord.
You could have withdrawn. I don't think you have a case at all. Heard Shreyasa, who learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India,
Okay.
challenging an order dated 9/4/2024 passed by the learned Civil Judge Senior Division number 1, Kamrup M, whereby petition number 6446 of 2023 in title suit number 246 of 2019 has been dismissed, full stop. By the aforesaid petition, comma, the petitioner, who was the plaintiff in the suit, had prayed for staying further proceedings as he had filed another suit in the meantime. Full stop, para.
Yeah.
This court has noticed that the petition under section 151 CPC was filed without stating any provisions of law for which the initial suit should not proceed. Full stop, para. Be that as it may, comma, that notice be issued returnable on 19th of July 2024. Let steps be taken for service of notice upon the respondents by registered post with AD. Steps within 3 working days. Yes.
Instead of 1926, my lord, 26,
You will not be there.
my lord, there is a problem.
Okay, 26th. 26th.
Interim, my lord,
No interim.
till then. My lord, on that day, it will be considered.
Let them come. Let us see.
My lord, notice be issued on the interim. That is my
We have not placed, we will not say anything. We would reject your interim order.
My lord, Notice be issued on that prayer also. my lord.
Don't insist.
Made.
May it please your lordship.
Yes.
My lord, the impin order is page 10, my lord. My lord, I am the defendant in the original suit, my lord. After my lord received the notice, my lord, I have filed a petition under order 7 rule 11, my lord, for rejection of plaint
You
Because-
are the petitioner is a defendant.
defendant, my
Defendant number?
sole defendant, my
So
lord.
defense suit for?
Suit for my lord, right title, interest and recovery of possession.
You file 711.
Yes. After hearing of parties, my lord, that was rejected and page 10 is the impin order.
Page 10.
Yes.
711 under what ground?
My lord, as the no cause of action, my lord, at all.
No cause of action.
Yes, ma'am. Just to make it NLC 711A.
711 Mijje case 409. 409. Mijje case 409.
Yes, yes, ma'am.
Order dated 16/5.
My lord, 16/5,
Page 10.
page 10,
Yes,
lord,
please read.
my lord.
Please read.
Yes. Both sides are represented. Today is fixed for order. I have already heard both sides. This instant petition number so-and-so is filed by the defendant petitioner under order 7 rule 11 read with section 151 CPC for rejection of claim. The petitioner by this instant application has categorically stated that the scheduled land covered by Dag number so-and-so situated at village Saukusti and under Beltola Moja may constitute a separate Dag from the land of the defendant petitioner, but it is stated by the petitioner that the land of the Don Bokso has already been properly demarcated by erecting boundary wall. In this petition, petitioner has denied the statement made by the plaintiff opposite party in paragraph number 6 to 11 of the plaint. Further, the petitioner defendant raised contention regarding lack of authenticate proof in the plaint in regard to the allegation of the encroachment by the defendant side. It is also stated by the petitioner side that the plaintiff has failed to mention any name of person specifically alleged to have encroached the land of the plaintiff. Hence, the plaint is liable to be rejected under order 7 rule 11A of the Code of Civil Procedure. On the other hand, the opposite party plaintiff by filing written objection stated that there is no deny of the fact of the possession of the land in the name of the Don Bokso by the defendant side. Further, the defendant after receiving the summons has appeared to contest the suit on behalf of the Don Bokso school. As such, the contention of the petitioner that no specific name has been mentioned in the plaint has lost its ground. It is further contended by the opposite party plaintiff that the defendant petitioner had forcefully occupied the suit land, due to which the plaintiff had to file this suit against the defendant. In this regard, the plaintiff has categorically mentioned the cause of action in the paragraph number 15 of the plaint. Considering the aforesaid fact and circumstances, it is indeed a settled position of law that the court has to read the entire plaint as a whole to find out whether it discloses a cause of action and nothing else. In common connotation to the expression cause of action refers to the bundle of essential facts which it is necessary for the plaintiff to prove before he can succeed. The Honorable Supreme Court in the Hiban versus Arvind Bhai Kalyani Bansali reported in 2020 7 SCC 366 unequivocally observed that the power conferred on the court to terminate a civil action is a drastic one, and the condition enumerated under Order 7 Rule 11 CPC are required to be strictly adhered to. However, under Order 7 Rule 11 of the CPC, duty is cast upon the court to determine whether the plaint discloses a cause of action by scrutinizing the averment in the plaint, read in conjunction with the document relied upon, or whether the suit is barred by any law.
Mr. Yasuddin,
yes, ma'am.
where you had filed 711 by contending that no cause of action appears.
Yes, ma'am.
We have just had a cursory glance of the plaint. A cause
See-
of action has been espoused in paragraph 8
My lord,
and in adjudication of a 711 petition.
yes, my lord,
Let us see 711.
lordship. My lord, first 711 rejection of plaint. The plaint shall be rejected in the following cases.
Yes,
A, my lord,
yes,
where it does not disclose a cause of action.
yes. This
That
is
is-
the
yes.
A you are trying to invoke.
Yes, my
You are not invoking D that it is barred by any
No,
law.
no.
To invoke cause of that there is no cause of action.
Yes, ma'am.
There is no question of you filing defense, then coming to a contest, there is no cause of action. Cause of action, there is absence of cause of action has to appear from a reading of the plaint itself.
Plaint,
If
my-
the from the reading of the plaint, no cause of action is seen
my lord.
to have been espoused,
Yes,
you may have a case. This is a very weak ground you are having.
lord. But
And
my
to
lord,
invoke this ground of cause of action, you have to make out a very specific case that no cause of action has been even expressed. Here, see, you read.
yes, my lord, I am stating that, my lord, Don Bosco, my lord, Don Bosco school, the land of the Don Bosco school is, my lord, separate in dark and.
That is the defense you are saying. You
Lord.
read paragraph 8.
Of the plaint, my lord.
Yes.
That the plaintiff beg to state that when the plaintiff has been possessing the suit land in the manner stated above, all of a sudden,
Yes.
on 5/7/2023, when the plaintiff and her son visited the suit land,
Yes.
then she saw that some person of the defendant entered into the suit land and they tried to develop the suit land. Then the plaintiff asked them why they entered into the suit land. Then the person said that they are employee of the defendant and the suit land belongs to the defendant. The plaintiff asked them to show valid document, but the person who were present at the time not able to show any valid document, and the defendant went away. My lord, this I categorically denying, my
No,
lord.
that's a denial. That will be the dispute.
Lordship.
The suit may be dismissed, but to preclude them from even going for a contest by invoking 711, this is not the purpose of 711. And what is your defense? What is your plea in your 711? That Don Bosco has not been properly represented, not properly.
That I forgot, my lord.
Then
Not-
what else?
Only cause of action part, my lord. Because, my lord, learned court below relied upon a, my lord, decision. My lord, I have gone through the decision, my lord, found that, my lord, when reading the plain, it's not mean that only plain, but the document, my lord, this is the word used, my lord, conjunction with, my lord. That means, my lord, the document also, my lord.
So how
But-
do you construe 711?
My lord,
711 will require a deep introspection of what are the documents. Or
Got it.
711 you have to make out a prima facie case. You are trying to invoke A is very weak.
but my lord,
No cause of action.
there is, my lord, if there is anything happen on that day, my lord, they have to
If
file.
you have to go to the documents and make a roving inquiry and come to the conclusion, no cause of action, that is a trial.
Nothing, my lord, on
That
that
will be a
particular
trial. You
day,
file your written statement.
my lord, on that particular day, my lord, nothing was happened, my lord. And
Third,
I,
dismissing this. Heard through Jiuddin Learned Counsel for the petitioner who
my
by
lord,
means of this
my lord, I may be allowed to withdraw, my lord.
who has filed this application under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure 1908. Full stop. The petitioner is aggrieved by an order that is 16/5/2024 passed by the learned civil judge, junior division number 2, Kamrup M, in Miss J 409 of 2023, in TS 362 of 2023, whereby the application filed by the petitioner, who was the defendant in the suit for rejecting the plaint under Order 7, Rule 11 of the CPC, has been dismissed. Full stop. The petition had cited that the defendant was not properly arraigned, and further, there was no cause of action. Full stop. Para. The learned court had, however, learned court by the order dated 16/5/2024 had, however, rejected the said application. Full stop para. Section, paragraph 8. A bare perusal of the averments made in paragraph 8 of the plaint, which has been annexed to this petition, discloses a cause of action, and therefore the order impugned does not appear to have does not appear to be an erroneous one. Full stop para. At this stage, Sri Jiuddin, the learned counsel, submits that he may be allowed to withdraw this challenge and he would contest the suit.
Yes, I
Full stop
would-
para. The petition is accordingly dismissed on withdrawal.
All right.
Item 10. Yes, what is this?
May it please the lordship. My lord, the petitioner put to challenge the order dated 4/1/2024, you lordship. Just 42 of the before the exiting court, you lordship. Because an ex parte judgment and decree was passed against the petitioner, your lordship.
No, just let us know the facts. Petitioner is what? Defendant?
Petitioner, lordship, defendant, you lordship.
One petitioner.
Single petitioner.
He was the defendant in a suit.
There are two petitioners, your lordship. One was the father and the son, you lordship.
Defendants.
Defendant. Two defendants. The sole defendant, you lordship, was the father. He died in the midst, you lordship. He died in the
Okay, okay, petitioner is defendant. The suit for?
decree specific performance and confirmation of positive.
Specific
Title suit.
Title suit for?
For specific performance and confirmation of position, you lordship.
Yes. Then what happened?
So, lordship, on receipt of the summon, you lordship, I did appear, you lordship. Although you lordship several dates gone by, you lordship, but eventually I have appeared and filed my WS, you lordship. And you lordship, an order 9 Rule 7 petition was filed and that was accepted, you lordship.
Okay.
Because an ex parte order was passed in the midst.
Initially, there was an ex parte. You had vacated it under Order 9 Rule 7.
Order 9 Rule 7, that was accepted and I have been allowed to file my WS, you lordship. And accordingly, I have filed the written statement, you lordship. So after that, you know, what happens is the lordship, the father expired, you lordship. And also the main engaged counsel, you lordship, Shiva Kumar, he was the engaged counsel, you lordship. That learned counsel also expired, you lordship. Shiva Santosh Koikia, you lordship. Then you lordship, the matter was taken up by the junior counsel, you lordship. And in the midst, father also died, you lordship, and during the evidence stage, you lordship. The petitioner, you lordship, could not appear and file reduce the evidence, you lordship. And accordingly, an ex parte judgment and order was passed on, you lordship, on 12/2/2020, you lordship. That is a stage 19. 12/2/2020, you lordship.
20,
you lordship. That is stage 19 to 33, you lordship. Stage 19 to 33, you lordship.
Ex parte judgment.
Ex parte judgment and decree, you lordship.
Okay, thereafter?
Thereafter, you lordship, I filed repetition under order 9 Rule 13 for seconding of the ex parte judgment and decree, you lordship. That is at page 34 to 41.
You got yourself implicated during the proceeding.
Lordship, yes.
No, you said the sole defendant had passed away. Father had passed away.
Lordship, because the title suit has been passed to, we have been arrayed, you lordship. The father and the, you lordship, the
Both,
petitioner have been arrayed as the.
both were defendants.
Defendant, both were the defendant.
Okay.
But the father was the defendant number 1, you lord.
Okay.
And I was the defendant number 2, you lord.
Okay, father was defendant number 1.
And I was the defendant number 2, you lord.
Okay, defendant number 1 passed away, you continued and you filed
written statement. Your
Okay, no, then you filed order 9 rule 13.
Order 9 rule 13, your lordship, and that is still yet to be decided, your lordship, during the pendency of the suit, your lordship. Suddenly I have received an notice from the executing court, your lordship, and there I have filed a petition under order 21 rule 26, your lordship, for staying your lordship, the executing proceeding. On the count that, your lordship, that since the petition
You
for
filed application under order?
order 21 rule 26, order 21 rule 29, your lordship. Wrongly, your lordship, this 29 is actually that would be your lordship order 21 rule 26, your lordship, instead of 29, your lordship. So that cannot be this a technical ground, your lordship.
Okay, now what has happened?
Now, your lordship, that during the because the yet to be decided order 9 rule 13, your lordship. So during the pendency of the suit, your lordship, I have filed a petition there out there, your executing court, your lordship, to stay the proceeding, your
Now
lordship.
that has been rejected.
But that has been declined, your lordship.
Which order?
By order, your lordship, is at page lordship, page 42.
4-1. Is it 4-1?
Lordship, 4-1, 2024, lordship. An order is also not clear, your lordship, and some
Page 42.
42, your lordship, Annex 4. May I read, your lordship?
Yes.
Both parties are represented by the engaged counsel. Today is the date fixed for necessary order. Earlier, the judgment debtor filed a petition by petition number 304/23 under order 21 rule 29. Read with section 151, wherein it is stated that the decree holder had filed a title suit being number 92/2015, which was declared against the judgment debtor. It is further stated that the judgment debtor that petition under order 9 rule 13 for setting aside of expiry judgment passed in title suit number 92/2015, and the same was registered as mid-J number 2/2020, which is pending. It is further stated by the counsel for the judgment debtor that during pendency of mid-J number 2 of 2020, the instant execution proceedings cannot be proceeded with, and according to the judgment debtor has paid for staying the instant execution case. The decree holder on the other hand, has submitted written objection against the petition filed by the judgment debtor, wherein it is stated that there is no provision of stay under order 29 rule 21. CPC, as stated by the judgment debtor. It is further stated by order 29 rule 21, speaks of suit and petition filed by the judgment debtor under order 9 rule 13 is not a suit, and it is a miscellaneous petition. It is further stated that order 21 rule 29 CPC doesn't as such comes into operation. Heard and peruse the case records. Order 21 rule 29 CPC lays down as follows. Where a suit is standing in any court against the holder of a decree of such court or of a decree which is being executed by such court on the part of the person against whom the decree was passed, the court may, on such terms as the security or otherwise, as it thinks.
Okay, well, under what provision it should be stayed? It can be stayed.
Because you lost it.
Under what provision of law? You said that you have wrongly incorporated order 21 rule 29 with and which is a suit.
It is reflected in the order.
Yes, then what provision? What would be the correct
Order
provision?
order 21 rule 26.
26. Please read 26. You don't bring CPC.
Order stay of execution.
Yes.
Order 21 rule 26.
Please.
When court may stay execution,
Yes.
the court to which a decree has been sent for execution shall, upon sufficient cause being shown, stay the execution of such decree for a reasonable time to enable the judgment debtor to apply to the court by which the decree was passed, or to any court having appellate jurisdiction in respect of the decree or the execution thereof, for an order to stay execution, or for any other order relating to the decree or execution which might have been by such court of first instance or appellate court if execution had been issued thereby,
or if application for execution had been made thereto.
Yes.
Number 2, where the property or person of the judgment debtor has been seized under an execution, the court which passed the execution may order the restitution of. So this will not come in the order 26 rule 1 would come. Your Lordship.
So what does 26
So
provides?
26 you lordship, because a reasonable opportunity should have been given you lordship
For
during the pendency of the execution proceeding. And here also you lordship. Another thing is there you lordship, because order 9 rule 13 petition is pending, that has not been decided you lordship. So if the order 9 rule petition order 9 rule 13 goes in favor of me you lordship, then ultimately the execution procedure would be
No,
rejected you lordship.
why don't you file an application in your application along with the order 9 rule 13 for stay of further proceeding?
Because you lordship judgment, because I have the option left you lordship, because when the judgment and decree has been passed against me ex parte you lordship, then the alternative remedy is lordship in favor of me.
Now,
either to file- either
is the executing court under an obligation to wait till indefinite period in absence
Lordship.
of any order?
lordship, there is a judgment also you lordship.
Yes.
Clear judgment you lordship. May I pass on?
AC to deliver, গরম হতে দেবে।
Because the same question raised you lord.
Yes, what is this?
Madhya Pradesh side.
Mohammad Iqbal.
Mahmoud Iqbal, you lost it. And in the middle of the you lost page number 2, there are some other citations also that has been indicated in this order you lost. Other 2 citations are there.
Which paragraph are you reading?
Lost it. Lost it. Para number 7, may I read you lost it? Para number 7. Because you lost it, the other side raised some objections. Despite the fact you lost it, para number 7.
Okay.
As the judgment debtor.
Heard Sri A.A. Diwan, learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, challenging inter alia an order dated 4/1/2024 passed by the learned civil judge, Junior Division number 1, Nagaon, in title execution number 10 of 2021. Full stop. By the aforesaid order, comma, the prayer for stay of the proceeding has been rejected. Full stop. Para. Please have your seat. The petitioner, along with his father, were the defendants in a suit for specific performance and confirmation of possession, which was registered as title suit 92 of 2015. Full stop. Though written statement was filed, comma, due to certain eventualities wherein the father of the petitioner, who was the defendant number 1, had passed away, and also the learned counsel who was representing the petitioners had also passed away, comma, the petitioner could not keep track of the said title suit, which was accordingly dismissed, which was accordingly decreed ex parte on 12/2/2020. Full stop. Para. Coming to know about the same, comma, the petitioner had filed Meet J, case number 2 of 2020 under Order 9, Rule 13, which is presently under consideration before the learned court. Full stop. In the meantime, comma, the petitioner had received notice from the executing court, and accordingly, the aforesaid petition was filed for stay of the execution proceeding, which has been rejected by the impugned order dated 4/1/2024. Full stop para. 3. The learned counsel has submitted that by mistake, a wrong provision of law was quoted in the petition as Order 21, Rule 29,
Instead of order
instead
21.
of Order 21, Rule 26. Full stop. It is submitted by wrong quoting or not quoting any provisions of law should not be a reason to reject a petition on that ground if otherwise on substance a case is made out. Full stop para. That notice be issued. The learned counsel has also referred to a decision of the Madhya Pradesh High Court in so and so, date to the date, parties now. Para, let notice be issued, returnable on 29th of July 2024. Let steps be taken for service of notice upon the sole respondent by registered post with AD. Full stop. Para. The learned counsel for the petitioner has prayed for an interim protection. Full stop. Para. Considering the facts and circumstances, comma, till the next returnable date, comma, further proceedings in title execution number 10 of 2021 pending before the civil judge, junior division number 1, Nagaon, shall remain suspended. Full stop. Para. The interim order, however, would be reconsidered on appearance of the parties. Yes.
Deep oblige, Your Lordship.
My pleasure.
Yes.
Petitioner before lordship is a dependent opposite party number 1A in a testamentary suit. We are agreed with the order dated 6/5/2024, whereby the cross-examination of PW2 has been dispensed. The impugned order is page 115.
Just a minute. Petitioner is
Defendant number 1A.
1A.
1A. He is contesting the
Suit for
testamentary suit. Generally, letters of administration was filed in 2007, was converted in 2009. Testamentary.
on contest. It was
Yeah,
converted into a
on
suit.
contest.
Okay. Then what has happened? You filed your written
Yes, written
statement.
statement, then it is converted to this
Suit. Okay.
testamentary suit. Then lordship, since 2009, it was for issue and valuation.
Suit was of which year?
2009.
2009.
Yes, lordship, I have annexed all the relevant order sheets. How it goes, I can show lordship.
Now what is the number?
Lordship,
Number of the suit?
1 of 2009. Testamentary suit number 1 of 2009.
2009.
Yes.
Then what happened?
Then it was fixed for
issue and valuation report. And valuation report was accepted on 30/6/2014.
Okay, then,
Then ultimately issue was framed on 10/12/2014.
okay, now what has happened?
Now, Lordship, what happened? Suit ultimately resumed. Thereafter, many defendant died. There was substitution.
Okay.
Ultimately, it was
10,
resumed.
12, what has happened? 10, 12, 2014?
The issue was framed.
Okay, issues framed.
Issues framed. Thereafter, we approached High Court, challenging the order dated 1960.
Now what, leave aside the history. Now what has happened?
Now, Lordship, on 29/2004, then again, it goes to 2024. It goes to cross-examination of PW 2 and 3/4.
29
29/2004 to 24.
for cross off?
Cross of no, for evidence of plaintiff side. For evidence of plaintiff side, on that date, service report on other defendants accepted and posted for 27/3/2014 for evidence.
Now 29 to 2024 was for evidence of plaintiff.
No, on that date, next date is posted for evidence of plaintiff.
When date fix?
27/3/2020.
Order fixing for evidence on
27/3/2024.
Okay, then what happened?
Then on that date, plaintiff submitted application that they already submitted at the examination chief of PW 2, PW 3 and 4 in the year 2015. So next date for 4/5/2024 for cross examination of PW 2.
24 for cross fix
Yes.
for
4/5/2024.
cross off
PW 2. PW 1 is not submitted. Evidence of PW 1 is not submitted. On 4/5,
now PW 1 not submitted means then why is it?
there is no evidence of PW 1.
Then why if a witness will be in accordance, whoever is give witness, plaintiff may not choose to give witness.
But PW 2 from PW 2 started.
No PW 1.
No PW.
Yes.
On 4/5/2024, we filed an application on the ground of illness of this respondent for instruction. She lives in Kolkata. That's why it was allowed, fixing 6/5/2024. 4/5 was Saturday, 5/5 Sunday, next 6/5/2024.
6/5, 2 days. 2 days thereafter. Thereafter?
1 day after.
Oh.
On that date, due to indisposition of the learned counsel, we filed an application on the ground of his illness. That has been rejected and cross-examination PW 2 is dispensed with. This is what we are agreed to. Illness is a sufficient ground for adjournment, Lordship.
Where is the rejection?
Page 115. May please. In petition bearing number 47/02, in petition bearing number 47 of the 02, by learned counsel Sushmita Patton, stating that the learned counsel is conducted and case has been suffering from illness. Hard on consideration, the prayer in the petition is rejected as the learned counsel representing the defendant has availed many days for cross-examination, but it did not appear for cross-examination in spite presence of it. But it was the 4/5/2024, after all these things, the first day.
But only PW 2 has been dispensed with.
Yes.
3 and 4 are still there.
3 and 4 are still there. And my instruction, there is also development lost. Next date was for 15/6/2024. We informed the court that we have filed this application and we also intimated that we will cross-examine PW 3 on that date. But ultimately court on that date fixed another date for PW 3 and also dispensed with the evidence of this cross-examination of PW 4. the latest development of things.
That order is not before us.
It is not before.
Will not like to stay a suit of 2009.
It is for not my different ground. I have annexed all the order states.
We are not attributing any fault upon you. Let the fault be taken by the court. It's a court's fault. Now will not be at fault. 2009 suit we are not going to.
Otherwise, the ship is completed. Everything is completed, then we will be executed. And what are important things, the ship originally a probate case was filed in the year 1993.
Mr. Purkasta, who was the opposite party?
Opposite party is one person, one Chandrasekhar Boni. Is my brother-in-law.
Suit is where?
Silchar.
Silchar. You serve him, Dusty.
On the council of the respondent.
Council, that may not amount to Dusty. You have the liberty to serve through the council, but we'll like you to serve Dusty. And will not stay this suit. You go ahead because PW4 is yet to be cross-examined. You go ahead with the cross-examination. We'll examine the issue. On his,
PW4 has been expunged. Now we'll file another application already dispensed with also.
three is there.
3 is there.
Three,
is there.
examine 3. We'll not say anything.
We'll examine 3.
Okay. Part 3 SD Purkasta, Learned Counsel for the petitioner who has filed this application under Article 227 of the Constitution of India, challenging an order dated 6/5/2024 passed by the learned Additional District Judge Kachar in testamentary suit number 1 of 2009, whereby the petition filed by the petitioner, who is the defendant number 1A for adjournment, has been rejected, and thereby the evidence of the PW2 has been closed. Full stop para. The Learned Counsel has submitted that there are good grounds as to why the adjournment was sought for, as the Learned Counsel representing the petitioner was unwell. Full stop para. Let notice be issued, returnable on, when is the next date there?
30th June.
Returnable on 19th of July 2024. Let steps be taken for service of notice by registered post with AD. Steps within 3 working days. Full stop para. 3. Purkasta Learned Counsel prays for an interim order. Full stop para. The suit is of the year 2009, and the next date is for the same is pending for cross-examination of the other PWs. Full stop. The Learned Counsel has, however, informed this court that as per instructions received, even the evidence of PW4 has been closed. Full stop. However, the aforesaid action is yet to be challenged. Full stop. Para. In view of the above, this court is not inclined to pass a blanket order of stay of the proceedings. Full stop. However, however, all further proceedings would be subject to the outcome of this petition with regard to the evidence of the PW2.
My problem.
Dusty?
That's it.
ऊपर में हाँ ऊपर में dusty rotate through the court notice में वो date okay and you have to file affidavit before the next date. You send him by courier and you file affidavit through your clerk. We just want to know that it was tendered and served.
Problem.
Courier not to the party, courier to your client.
Fine.
Make clear your lord. So in this case, petitioners is the plaintiff, my lord, aged about 78 years, my lord, having serious heart ailment, my lord. His filed this suit for
Just a minute.
and
Petitioner,
the plaintiff, my lord.
sole plaintiff,
Uh,
sole
his
plaintiff.
wife is also, my lord, one of the plaintiff, my lord, but mainly the petitioner number one, my lord.
Along with wife. Both are, there are one. Two petitioners.
Two petitioners.
They are plaintiffs.
My lord.
Plaintiffs.
My lord, now petition.
Suit for?
Suit for right, declaration of right title interest, recovery of possession and cancellation of sale deed.
Right title interest recovery.
And cancellation of sale deed and injunction, my lord.
Recovery of possession, cancellation of sale deeds.
My lord.
And?
An injunction, my lord.
Injunction, okay.
My lord. Well, thereafter, my lord, the plaintiff along with two other witnesses, my lord, has filed his evidence on affidavit, my lord. And then, my lord, this COVID period has started, my lord.
PWs, three PWs.
Three PWs, my lord.
Filed evidence.
Evidence, my lord.
Filed affidavit.
Affidavit, evidence, my lord.
Okay, then?
Then, my lord, when COVID restrictions started, then, my lord, after that, my lord, this petitioner number one, my lord, who is having serious heart ailment, my lord, has been suffering from heart problem. And on 16/12, my lord, that is at page 60, my lord.
16/12, which year?
16/12/2023, my lord.
Yes.
Is one of the impugned order, my lord.
The title suit is of which year?
14, my lord.
14, title suit number?
It is 15K plus 2014, my lord.
15K, what is K?
K means Foliabor.
Foliabor, okay.
And
Then
my lord,
16/12, what had happened?
my lord, the impugned order has been passed, my lord.
16/12,
My lord.
what is the impugned order?
Rejecting my petition for adjournment, my lord, on the ground of treatment, my lord. May I read, my lord? Short order.
Adjournment rejected. Page?
60, my lord.
60.
60, my lord.
Please read.
Whereby my petition number 1163 plus 23 has been rejected, my lord. The counsel for the plaintiff submitting during that may I read, my lord.
Please read, yes.
My lord, in the petition number so and so, counsel for the plaintiff submitting therein that the plaintiff is not able to present today due to his ongoing treatment and hence prayed for another date for cross-examination of PW's heart. The learned counsel for the defendants objected to the petition. Peruse the petition, the case record. Perusal of the case record shows that while order dated 12/10/23, final opportunity was given for cross-examination of PW's official witness on the ground.
Okay, the petitioner number one was not well, heart patient. What about the other two petitioners, witnesses?
My petitioner to bring the other witnesses because he has fallen ill, my lord, and he has immediately after that, my lord, he has suffered stroke, my lord.
No, that is okay.
My lord.
That is for the petitioner number one.
My lord.
Who's the PW1?
My lord.
What about PWs 2 and 3?
Because, my lord, all the witnesses.
One witness may not be able to come
My
because
lord,
of some
my
reasons.
lord.
The rest of the
But it is
witnesses,
the plaintiff, my lord, who has to bring other
Why?
witnesses, my lord.
why? Where is the requirement? It's for examination, cross-examination of the evidence of
My
the
lord.
witnesses. Whoever witness is there, you should come. Whoever is not there, you file an application.
My lord.
You file an application showing cause for one witness.
Only play, yes, my lord.
One
plaintiff,
witness. What about the
petitioner.
others? Even if we allow you for PW one, what about PW two and three? No reasons.
Well, since he is in serious treatment health, having serious health issues, my lord.
Serious health
the other
issue,
witnesses
serious
also
health
could not
issues
be
is for
convicted, my
PW
lord.
one, we'll consider.
My lord.
But how can we consider for two and three?
Because since he is ill, my lord, the other witnesses could not be contacted by the council, my lord. Because it is the plaintiff, my lord, who is known to the
Admittedly, there are two plaintiffs.
my lord.
Maybe the wife is the plaintiff number two.
My lord.
She has also not come.
Well, she has, because my lord,
And what about the
her
PW
husband-
three? What about PW three?
because of the plaintiff's health issues, my lord, they could not be contacted, my lord. He is in hospitalized, my lord. Immediately after that, he
Suit
was
is of the year 2014.
14, my lord.
The order has been passed almost after 10 years, where your prayer for adjournment has been rejected, rightly.
Only one date, my lord, will be required because, my lord, he has suffered stroke, my lord, and that's why,
When
my
did he
lord,
suffer stroke?
stroke immediately after that, my lord, in the January 2018-24, my lord.
Hmm?
He was suffering from heart ailment, my lord. On 28/1/2024,
This order was of 1612. What
lord.
was happening on 1612?
my lord, because of his ailments, my lord, the council has short time, my lord.
Where is the document?
Document, my lord, that time, no documents was the next, my lord.
Put
Thereafter,
out
my lord,
document.
I have next is page 62, my lord.
62 is of which date? Is of 28 January.
My lord,
This is of 16th
After-
of June.
my lord. Thereafter, I have filed another petition, my lord, immediately on the next date, my lord. That is page 63, my lord. I'm taking only one day, my lord, because now, my lord, he's in a position to bring all the witness along with him, my lord. Matter of single day, my lord. Otherwise, my whole suit.
We cannot allow your petition without hearing.
Right.
And even if we hear and we allow the petition, we'll impose cost. But that's a different matter. Some rights have accrued upon the defendants. We cannot
But since long time, my
pass
lord, the other
orders
side was,
without hearing them.
my lord. Problem is that next date is on 26th, my lord.
20?
6th of June, my lord.
You serve dusty upon them.
I'll try, my
Or
20, before 26th.
Sri P. Sundi, learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, challenging an order dated 16
12/23,
12/2023,
as well as 9/5.
followed by another order dated 9/5/2024 by the learned civil judge,
Junior.
Junior Division, Koliabor, Nagaon, in title suit number 15 K of 2014. Full stop. The petitioners are the plaintiffs in the suit. Full stop. It is submitted that though 16/12/2023 was fixed for cross-examination of the plaintiff witness within bracket three numbers, comma, due to the ill health of the petitioner number one, who was the PW one, comma, a prayer for adjournment was made. Full stop. However, wide the impugned order dated 16/12/2023 the prayer has been rejected and the matter has been proceeded by closing the cross-examination of the PWs. Full stop para. By the subsequent order dated 9/5/2024, comma, the learned court has refused to interfere with the earlier order dated 9/5/2024, full stop para.
16/12.
16/12/2023, full stop para. The learned counsel has submitted that there were sufficient reasons for seeking the adjournment, as the petitioner number 1 was suffering from serious ailment of the heart and was also hospitalized subsequently. Full stop para. Let notice be issued returnable on 22nd of July 2024. Steps, registered post with AD, 3 working days. Dusty. Okay. Para 3. Sundi. Learned counsel prays for an interim order. Full stop para. The interim order. The suit being of the year 2014 and the impugned orders do not appear to be ex facie erroneous, and therefore this court is not inclined to pass a blanket interim order. Full stop. However, and in fact, this court is of the opinion that even if the impugned orders are interfered with, comma, the same can be done by imposition of certain cost. Full stop. However, the notices are required to be served upon the contesting respondents. Full stop. Accordingly, till the next date fixed, comma, it is provided that further proceedings of the title suit number so and so before the so and so shall remain suspended. Full stop. The aforesaid interim order would, however, be reconsidered on the returnable date. Yes.
59 subpoenas.
Yes.
This revision petition is filed against the judgment, common judgment order dated 23/2/2024, page 89.
Page 89.
88. 11/90. Out of the same LA number 14 of 1990, the parties are the same board. Reference are taken with the disposal of the by the common judge. Petitioner doesn't look back. Well,
Just a minute, please. Just a minute, Mr. Rotta. The petitioner is the IIT.
IIT part.
And this revision is against what?
My lord, reference case was filed.
Okay.
We have contested the case.
Land was acquired.
Land was acquired.
Land acquired.
Acquired by the instance of MHRD, Government of India.
Acquired by MHRD. Then for
by
IIT Guwahati.
By the
land acquired for IIT Guwahati. You are the beneficiary.
Not beneficiary, my lord. Because I am going to publish this that we are education institute. We have no fund generating institute.
No, we are not on the funds, but it is for you. You are the beneficiary.
My lord, it is a, post allotee, we are post allotee. First acquired the land by the MHRD and the payment was made by the MHRD to the government of
Okay,
Assam.
cemetery, okay.
And therefore, that land was allotted to IIT Guwahati.
Okay.
That is why,
There was a reference. There was a reference.
yeah,
Reference court has enhanced the compensation.
compensation.
Okay.
We have no objection for enhancement of compensation.
Yes,
but
yes. Now what has happened?
my lord, we are contesting the case that we are not necessary part in the reference case. And the court has at page para 4 of the that page 92.
92.
92.
Yes.
Upon receipt of the petition submitted under section 18 of the Land Acquisition Act, the district collector referred the two applications to this.
Now let us
and
see the operative part where you agree by the
Operative-
judgment. The petition under compensation.
My lord.
for- Declared amount in 2 months. OP number 2, IIT has been directed to make the payment. That is your grievance.
Yeah.
You said that the payment, if any, have to be made by the MHRD, the Ministry of Human Resource. Is that your case?
Yes, my.
You have
In this year, under that land was acquired for the public purpose. That money will go from the public sector. So MHRD are the requiring department.
No, that is, have you written to the MHRD?
Another,
Now, have you written to the MHRD for funds?
my lord, in that the process of acquiring, we had no rule.
Mr. Doctor, have you written to the MHRD
Yes,
for
my lord,
funds?
to several times. to-
Where is your letter?
My lord, in this case, not. In
You write to
several
the
cases,
MHRD.
But here,
Why do you come up with a technical plea that it's not for you? You may be the allottee, but you are a creation of a statute. You have the MHRD above you. Write to the MHRD, get the funds,
in this case, my
satisfy the
lord,
decree, matter ends there.
I am made
Now,
up.
by challenging this, won't it amount to frustrating a decree?
Lord, my lord, in this issue, I relied on the one judgment, my lord, with
Yes.
regard to post LOC. The post LOC is for the necessary part in the reference case. There are 9, my.
Paragraph 9.
Yeah, there are 9.
Please read.
To determine the question of whether the post acquisition allotee of land is necessary of proper party or has any locus to be heard in the matter determination of compensation, we may refer the scheme of the act. The acquisition may either be for a public purpose as defined under section 3I for company under part 7 of the act. If the acquisition is for a public purpose, as the present case, the land based in the state after collector makes an award, the position is taken. Till the award is made, no person other than the state come into the picture. Once the land vested in the state, the acquisition is complete. Any transfer from the state is not concerned with the purpose of acquisition. The state may transfer the land by public auction or by allotment at any price with which the person whose land is acquired has no concern.
the mere fact that the government chose to determine
This is
the
in the
allotment.
context where the appeal was filed by a post LOT. Now your post LOT is already made a party in the proceedings, reference proceedings. Now, and this is against the final decree. How have you come against in a revision?
Because my lord, the common judgment is first that earlier the IIT Guwahati has paid land compensation to others, and this judgment was this award was attained a finality. In this regard, this honorable court in its judgment, my lord, passed in CRP 2024 or 2014, it made it clear that
No, you have a remedy under 54 of the Act to file an appeal. This is a order passed in a reference. It's as good as a decree.
14, my lord. Moreover, from the contents of letter dated such and such issued by the Undersecretary of the Government of India, Ministry of Human Resource Development, New Delhi, Annex 5, T to the rejoinder of the petitioner filed on such and such, merely because the Government of India had released the award and interest in execution cases bearing number such. Money execution number such and such, he is unable to treat the petitioner as a judgment debtor. And those execution cases in view of the fact that was order dated such and such by the learned district judge Kamrup, wherein those execution cases, wherever decree holds therein were directed to take step for execution of award against the collector, only as the petitioner, that is.
Okay, we'll come back at 2 o'clock. There may be slight delay, maybe 2:15. Video conferences, you know? Video conference kita narrated for judgment. Narrated bohem nahi. Itu kori hai. ঠিক আছে। Narrated bohem. Okay. Kori. Kori.
Hold item. Just a minute.
Brother will pronounce the judgment. Brother Habu?
Yes, please.
Let me pronounce the judgment. We'll formalize the part later on and send it to the Nagaland. But the appeal has been dismissed. And we have made an observation that the promotion to the next higher post shall be made strictly in accordance with the criteria laid down in the rules. We'll send across the judgment, Brother Habu, to you.
Okay, thank you. Thank you. Okay, can disconnect.
My lord, once again I am bearing before you, so my lord, that we are not challenging the award.
Correct.
But implement and direction of the court by rejecting the petition filed by the IIT.
Now, the order which you are trying to rely upon of this court is an order which was passed in a petition under 227, whereby you were implicated in the execution proceedings. Now, here by this 227 petition, you are challenging the decree, the order of the reference court.
Yes.
It's almost a decree. How can you challenge a judgment under in a revision?
My lord, at the time of passing the order, they have rejected our.
So you have a remedy under 54 to file an appeal.
Because there is provision of appeal before this court, my lord.
File an appeal.
because of not challenging the award, we have no objection. But
No, you have
we just-
challenged the award.
we are
This-
not
the-
challenging that how much money we have.
Then what is the subject matter of challenge?
My lord, only to implement.
Where? Where is the order? The
Opponent.
order which you have put to challenge is the final judgment of the reference court.
That they have treated us, the honorable Learned Court, my lord, treated us as beneficiary.
No, challenge it in the appeal. What is the scope of revision?
But our petition file, rejecting the petition, my lord,
Where?
petition is 59.
Where is the rejection?
Uh,
Where is the rejection order?
This is the petition for,
Where is the rejection order? This is an order by which you are directed to pay. If you are aggrieved, you file an appeal under 54. The earlier case was wholly different. In the execution proceeding, you are implicated as a party. You came before this court. Here it's a different matter. You are a party in the reference proceeding. Judgment has been passed. It amounts to a decree. You can appeal under 54.
another matter is that they have filed in this case the respondent and landowner for enhancement of
Mr.
enhancement
Datta,
of-
that is the appeal. That is the reference under 18. And the appeal reference has been answered by this judgment. If you are aggrieved, you are a party interested, you can file an appeal under 54. Matter ends there. How can you invoke 227?
enhancement petition has been pending before the court now. Review petition. Review
That's a
petition.
different matter.
And let this matter may be taken up in some other day. It is
No, you are ultimately what is in challenge? It's the challenge judgment and order of 23 to 2024. That is by the reference court.
102, 102 my lord.
102.
Of the judgment. Order.
Yes,
In view of the foregoing discussion,
yes,
the reference numbers such and such are allowed. The
yes,
petitioner is entitled to compensation of the land
Yes.
assessed at the rate of such and such
Yes.
per year.
that is
And
the final
the
order.
direction, the opposite number 2, IIT Guwahati will make the payment of the technical amount to the petitioners within.
You are
12 months.
aggrieved, file an appeal. Where is the scope of revision when there is a provision for appeal?
Yes, my lord.
You file an appeal if you're aggrieved. Heard. Sri A.K. Datta Learned Counsel for the petitioner who has filed this petition under section 115 of the Code of Civil Procedure 1908, read with Article 227 of the Constitution of India against common judgment and order dated 23/2/2024 passed in reference case number 83 of 2016 and reference case number 84 of 2016 by the learned district judge Kamrup. Full stop. The aforesaid judgment is passed by the learned court as a reference court under section 18 of the Land Acquisition Act 1894. That's not Land Acquisition Act. Full stop. The aforesaid act provides for preferring an appeal under section 54. And when the statute itself provides for an appeal, a revision is not maintainable. Full stop. The revision is accordingly held to be not maintainable. Full stop. The petitioner is, however, at liberty to prefer appeal in accordance with law. You want certified copy?
Yeah, we shall file my lord, liberty may be granted.
We have already, you want certified copy of this?
Yes.
We'll return the certified copy. The registry is directed to return the certified copy so as to enable the parties to prefer appeal if so advised.
Apply.
Yes, yes. Just some basic facts we note down, then we close this.
Well,
Appeal is by the insurance company.
my lord, the total compensation your lordship will find 22,05,000,
Insurance
and the
company.
future prospect is 31.
No, your appeal grounds are on future prospects. Interest has been granted.
Future prospect and monthly salary will be reduced down from 15,000 to 14,000. Difference one
Monthly salary
shall be taken
was
14,000.
held to be 15.
15 and
To
now,
be 15,000.
my lord,
It should be
14,000.
14,000.
14 into 12 yearly it will be.
Okay, then what about the future prospect?
Future prospect is coming for the last item your lordship kindly see. 4,41,000.
Yes.
No interest will fetch on this.
Here their interest was also levied on the future prospect.
Yes. So these are the two
Interest was
pieces.
directed to be paid on future prospect. No interest payable.
Yes.
As per what? Which judgment?
That, yes. Let me understand. Let me find out. My lord, I'll place it before your lordship tomorrow.
No.
There are so many judgments, but
Give one judgment at least, citation we can write.
it's not readily here, my lord.
Even Pranay City, I think, has said interest on
Pranay
future.
Shetty, it was not called upon to decide that. It's by this
No,
honorable
but
court.
there are decisions.
There are many decisions of this honorable high. One is by Justice
No, there are Supreme Court judgment.
on future prospect.
No interest on future prospects.
On that issue, I don't think
There are.
Sulachana Devi was the first one decided by this honorable. And in Pranay Shetty, the Supreme Court has never called upon. So far, this question is concerned. There are decisions by Justice Michael and Justice Durana.
So ultimately, it will be 4,41,000.
Future prospect is 4,41,000
4 lakh interest will not be applicable
on this amount.
4,41,000 apart from that amount. The other award will carry interest.
Yes, now total, how much will be the total now?
Total is 22,05,000.
This future prospect you have.
Including future prospect.
So from 22,05,000, 4,41,000 will be deducted, and on that amount, just will be applicable.
Okay. Total 22,05,000. And this includes?
This includes
441,000.
Yes.
That means 4,6,1,7. That means on 17,64,000 interest will accrue and 441 interest will not accrue.
Yes.
Till now, what has been paid, Mr. Chaudhary?
I think 50%, my lord.
50% has been paid.
Yes, yes. The order was that to pay 50% and that amount has been paid. 50% of the awarded amount.
Now, after the remaining, which amount will you consider as future prospect? Let us consider the amount paid to include future prospect.
Lord, the term as my lord indicated to me by my client, it was like that.
Okay, then it's good. Then the rest of the amount he'll get interest.
I leave up to your lord.
Okay. We'll dispose today's
Well.
date. Madam Chaudhary, you are assisting Mr. Datta. Okay.
I thought she might have carried that decision, but she's also like me.
Two M. Chaudharys. Datta in between two Chaudharys. Secured or danger?
Your lord, she will decide.
Will not decide.
From my side, my lord, is
Oh, you are putting an allegation on madam.
not exactly.
Okay.
Obliged.
We'll dispose it off.
Bye-bye.
It was a death case.
Yes.
And who are the claimants?
Same as the wife. Wife
Widow.
and yes, widow.
Was there any
Children also.
was there any revision of proportion of payment indicated?
My lord, no, no. It's not there. my
Oh, it's not there. Okay, good. How old are the children, Mr. Chaudhary? How many children? How old are they?
My lord, total 3 children.
3 children. How old? How old? Any idea?
Claim.
Four children are there. Along with their mother.
My lord, now presently, my lord, there will be
4 children.
4.
4 children, my lord. 18 hole थे कि मानो.
At the time of filing of the claim petition in the year 2016,
18 years.
one was 18 years, 16 years, 14 and 12. That's one number 2, 3, 4 and 5.
12. 12 is also all have become major now.
Yes.
Yes.
Okay. They are also claimants.
Claim.
That's why deduction came to 1/4.
No, would you like to have it distributed in a particular manner?
That's your perception.
No. It's up to you.
It
Their
may-
mother is
Yes.
also there.
Mother is also there. And 4.
The whole
children
amount
are
can
there.
be given to the mother. The mother will distribute them, or what? You tell us.
1/5 to all of 5 claimants are there.
Mother may distribute.
Tribunal did not say anything.
No.
Okay.
Obliged.
Aditya disposal.
It's the Lordship. Lordship, this is a statutory appeal. In fact, the analogous appeal has already been admitted. Lordship. sir,
There
if
was,
you
there
doubt-
was delay condonation.
Yes, Lordship.
Delay has been condoned.
Condone Lordship that the respondent number 1 and respondent B had striked out 235. Respondent number 1 served and respondent number 4, Lordship. In fact, 1 and 4 are he's the 4 is husband
So
of.
that was in the delay condonation proceeding.
No, we will take steps
Okay,
again.
now we have to take steps.
And I think for 6, he's appearing.
Your Lordship, I am appearing for respondent 6.
6.
New
Okay.
India.
Okay. Now, heard. Miss R.D. Mazumdar, Learned Counsel, who has preferred this, Learned Counsel for the appellant, who has preferred this appeal under section 173 of the Motor Vehicles Act against the judgment and order dated 2/2/2017 passed by the learned MACT Nagaon in MAC case number 513/2011. Admit, call for the records.
Steps, Lordship, I would like to pray that we take steps by Dusty on 1 and 4, Lordship, because Lordship, in the delay petition also lots of time went for that.
Shri S. Datta, Learned Counsel, accepts notice on behalf of respondent number 6. Steps for the other respondents be taken in usual manner. List after 6 weeks along with service report. Full stop. The prayer for permitting dusty service would be considered depending on the service report.
Lordship, 2, 3 and 5 were striked out in the delay petition, so they stand striked out. I do not.
No. They have to struck off in the appeal.
Okay,
Delay
and
conduct-
then Lordship, we can
You
strike them
take,
out.
no, if you make a prayer, we can.
Yes, I'm making a prayer to strike them out. 2,
Which
3 and 5.
steps are going to give her. At this stage, Ms. Mazumdar, the Learned Counsel submits that the respondent, that the names of the respondent numbers
2, 3 and 5.
2, 3 and 5 may be struck off, which was also done in the connected delay condonation petition registered as IA. Delay condonation কিমান আছিল? Delay condonation.
Delay, Lordship, was 1304 of 2018.
এটা নাই নহয় delay খন। Delay বুলি ক'লে হ'ল না, এইটো stay petition. Delay condonation was IA civil 1304 2018. কি ক'লো লাষ্টৰ খিনি? Full stop. না তাৰ আগৰ লাইনটো কৈ দিয়ে। Has praised for striking off. Praise. No, praise for striking off. Struck off কেনেকে হ'ব? Praise for striking off. Maybe struck off. Connected. Accordingly, the names of the respondent numbers 2, 3, and 5 are struck off from the array of parties. The Learned Counsel for the appellant would accordingly submit an amended cause title.
That won't be,
No, because otherwise there will be confusion.
because registry will strike out Lordship with red. I think court secretary can do.
Yes, difficult. Take body. To remove any confusion, the numbers as originally put would however be retained. Full stop. Then as Dr. accepts for 6.
Yes, sir.
6, and you will take steps for 1,
and three, four, sorry.
1 and 4, 1 and 4. ঠিক আছে? By
Will I-
usual process.
Will file amended?
No, not required.
Not. Highly obliged.
Melody, Lordship, kindly excuse me.
Yes,
The
please.
earlier matter, one line may be added. The statutory amount may be refunded to
Okay,
the.
25,000.
My,
আছে নাকি ফাইলটা? Okay, we'll do it.
Lovely.
May I please.
Yes, please.
Last application, Lordship, heard the matter and fixed because Lordship, the main respondent, Lordship, respondent 1 to 4 was absent. Lordship, last two. That was the last one.
Yes, they have come or not?
No.
Main respondents, councils are there.
Yes, council name is there, Lordship, service complete. They were the plaintiff, Lordship. Otherwise, Lordship heard the matter on last occasion regarding Lordship implement Lordship, order 1 rule 10(2). The present petitioner is impleted as a main respondent.
This has come up for admission.
Yes,
There's an interim order.
yes, to stay the order. My implement order was.
Let us admit this matter then. And it will remain stayed.
Okay, otherwise also Lordship may dispose of the matter, Lordship, because last 2-3 occasions they are accepted.
Disposal may be against you.
Then Lordship can fix the date for
That is
admission.
the reason.
Yes, then Lordship can fix the date for admission, Lordship.
Amendment includes implement.
But
There is
but
no requirement to give you a hearing before.
other
implement.
aspect of the matter, Lordship.
Other aspect, how are you prejudiced? How can it be prejudiced?
But Lordship, whatever Lordship in this case, before Lordship registration,
Let
Lordship,
us not go into all this.
then Lordship can fix another date for admission.
After the vacation.
Yes, can fix the date.
Heard Miss MP Bhattacharya, learned counsel for the petitioner. Also heard Sri A. Bhattacharya, learned counsel for the respondent numbers 5, 6, and 7. Full stop. The respondent numbers 1, 3, and 4 are not represented even today. Full stop. On the last two occasions, that is 10/6/2024, as well as 18/6/2024, the same situation was prevailing. Full stop. Para. In the interest of justice, release this case. In the interest of justice, matter is adjourned. We will stay immediately after the summer vacations. Full stop. Interim order passed earlier to continue till the next date of listing.
Date may fix.
Why are you asking for date?
Yeah, it's emergency because
What urgency?
Lordship, the order is stayed. In fact, Lordship, that suit is also stayed. Otherwise, suit is not proceeded there.
Which
Although
suit?
there is no stay for operation of the
Which suit?
that main suit, Lordship. That is also
That is not your suit.
not my suit, Lordship.
Then-
That is.
How are you bothered? We see some collusion, madam.
No, Lordship.
Yes.
No, because
You
Lordship,
want the suit to go. You want the,
otherwise, for my because of filing of this petition, that suit is Lordship not proceeded. That is my instruction. Is that
there is an interim order, we'll vacate it then.
no, Lordship.
Yeah.
Then after
So Bhattacharya's, apparently there is collusion.
only my case is to hard me before
We are not pointing out that you are from the same chamber. Okay.
met visible. Lord, this is the matter has been posted on request. And this is application 227 against an order rejecting the prayer under order 7 rule 11.
You're the defendant in the suit.
We are defendant.
How many petitioners?
Petitioner 2.
Two petitioners.
2 petitioners, 2 defendants.
Suit for?
Suit for declaration of cancellation of the deed still and cancellation of still. Notice has been served, but the respondent, so there are 9 numbers, the plaintiff.
You filed 711.
Yes.
You filed 711.
Yes.
What ground?
On the ground that the suit is apparently barred by limitation. The suit could not have been instituted after lapse of
D. 711D. Barred by limitation.
Yes, this was the ground out, but I will place before the Supreme Court also that suit is apparently a vexatious and it is a bogus litigation brought in, which the learned court ought to have.
This ground of limitation, can it be, is it so apparent that a bare reading
Yes,
of the
my lord.
plaint?
Yes.
Let us
Yes.
let us see.
Sorry.
Let us see. Let us
Yes,
see
yes.
the, let us
Yes.
browse through the plaint.
Kindly see, let me first go to, I will take your lordship to the plain little letter. Kindly see the order of the learned court below. Starts at page 52. 53. 53.
The impugned order.
Impugned order.
Yes.
It says, let me place it. A second para.
Yes.
In the petition, the defendant stated that late Sarana Toikia, of whom the plaintiff claimed to be the legal heir, was the original owner of land measuring 1 bigha 2 kata 4 letters covered by tag number 2562 of KP Patta number 579 under Ulvari Moja district of Petro. The plaintiff alleged that the husband of the defendant number 1 manufactured a forged title deed bearing number such and such dated 24/12/86. Title deed is dated 24/12/86. In the name of the defendant number 1. According to the plaintiff, their predecessor in interest, late Tarana Soikia, had not executed said title deed, and the signatures of Tarana Soikia were obtained fraudulently by defendant number 2, and therefore the plaintiff sought for declaration to the effect that the state title deed is illegal and fraudulent and prayed for cancellation of the sale. He stated that the suit is barred by limitation as the relief for cancellation of the sale deed is governed under Article 59 of the Schedule of the Limitation Act, which provides the limitation period of 3 years, and hence the time limit for preparing the instant suit has been expired 34 years ago. It is stated that the original vendor, that is late Tarana Soikia, never challenged the sale deed in question during his lifetime. Further, the document number 3, the Jamabandi of his land, filed along with the plaint, shows that the name of the defendant number 1 was mutated way back on 3/9/1990, and since that date, the defendant number 1 has been paying the land revenue. It is further submitted that the plaintiff number 9, that is the wife of the deceased, obtained a mutation in the year 2013, and hence the plaintiff number 9 ought to have knowledge of the sale deed. The plaintiff number 1 has been paying land revenue in the same patta and dag number, where the defendant number 1 has also paying the revenue. Therefore, it can be concluded that the plaintiff has sufficient notice in respect of sale deed. It is also stated that the plaintiff filed the suit after lapse of period of limitation by falsely stating that they got knowledge about the sale deed on 1/7/23, and hence prayed for the plaintiff to be rejected. Second paragraph, next page, these decisions were cited. The plaintiffs filed written objection stating that the defendants have misconceived and misconstrued the provision of Article 59 of the Indian Limitation Act. As per the said article, the period of limitation is fixed at 3 years, which runs from the date of knowledge. The plaintiffs have stated in the plaint that they discovered about the fraud after receiving copy of the sale deed and Jamabandi from the defendant on 1/7/23, and that before 1/7/23, the plaintiffs had no knowledge about the sale deed. Under such circumstances, the limitation for filing the suit starts from 1/7/23. The plaintiffs also stated that the apex court and different high courts have held that point of limitation involves a bundle of facts to be considered together for deciding the same, and matter of law and fact has to be adjudicated while the issue of limitation is decided and the suit of
Why did they receive the copy of the sale deed on 1/7/1993?
Sorry, Malay. They say
They say that they got knowledge
only
on
on,
receiving of the copy of the sale deed and Jamabandi on 1/7
they received it from me.
from you.
From me.
Why would you
Why
give?
should I? Because what happened, my lord, here? That is why I said, my lord, the way they are trying to cover up the whole story and to project that
Where is your case, Aravindam?
Arabindam. My lord, yes, I'm 77-4. Yes, I'm on that much. It's a totally vexatious case.
Justice Krishna. right?
Yes, Justice Krishna decision, paragraph 5. Crafted. Yes.
Cleverly drafted.
Cleverly crafted plaint. The court is to meaningfully read it and find out what is what there. That is why I opened my argument saying it's a totally vexatious case. Nothing is there. They are trying to.
Yes,
cover-
where is Aravindam?
Yes. Lordship may see it is 77-4 SCC 467. Paragraph 5.
77-4 SCC 467.
77-4 SCC.
Yes.
Paragraph 5. I'll copy on that. Should I pass it on?
Amma aseni.
Yeah, pick up 9 here.
Should bring a photocopy, madam. Or at least you should have given a list of books. Light up again. Citation disabled book. Huh? It does.
Those photocopies are different.
Yeah, no.
This decision is not there, madam.
I don't know.
No? No, so that
Yes, I don't know. This is, you have not given Aravindam.
But you
No,
have given 2 photocopies and you have given citation for this.
Citation.
this photocopy has not been given. Arindam is not Arabindam.
Just a minute. It may be there. One second. Yes, it's there.
Is there, my lord? So kindly come to paragraph 5.
5.
Yes. We have not the slightest hesitation in condemning the petitioner for the gross abuse of the process of the court repeatedly and unrepentantly restored to. From the statement of the fact
Resorted to.
resorted to, sorry, yes, resorted to. From the statement of the facts found in the judgment of the High Court, it is perfectly plain that the suit now pending before the First Municipal Court, Bangalore, is a flagrant misuse of the mercies of the law in receiving plaint. The learned Muntip must remember that if on a meaningful, not formal, reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue, he should exercise his power under Order 7, Rule 11 CPC, taking care to see that the ground mentioned therein is fulfilled. And if clever drafting has created the illusion of a cause of action, nip it in the bud at the first hearing by examining the party searchingly under Order 10 CPC and activist judge is the answer to irresponsible lawsuits. The trial courts would insist imperatively on examining the party at the first hearing so that bogus litigation can be shut down at the earliest stage. The penal code is also resourceful enough to meet such men and must be triggered against them. In this case, the learned judge, to his cost, realized what George Bernard Shaw remarked on the assassination of Mahatma Gandhi, quote, "It is dangerous to be too good." So, now,
Okay, now yes.
here, kindly see at the first instance, their predecessor was alive for 21 years. After this sale, it was a, he never made any challenge. After his death, his wife, the plaintiff number 9, she obtained mutation. Kindly see at page 51. She obtained mutation in the year 2013. Then she knew that our names are already there. And her name was included along with our name. Another procedure was also there. At page 51, kindly come to. This is the English rendering of the
51.
German mutation. This was placed. The learned court below has not referred to it. Not considered that.
Yes.
At 50, it starts from the annex of 5. Here. In this patta, there are names. Number 2 is the Ghanakanto. Number 3 is Orup Chakraborty. Number 4 is my name, Icon Hoikya. Icon Hoikya is my name. And number 5 is Hemaprabha Hoikya, wife of the Tarana Hoikya. Her name was included. Now, in that, kindly come to this noting. Mutation of applicant for Sri Orup Chakraborty along with Pattada Tarana Hoikya is granted against the plot of land so-and-so in DAG number such and such against sale possession case number so-and-so date 86. Signature eligible. Name of the applicant for Srimati Icon Hoikya, wife of the Ramchandra Hoikya, against a plot of land measuring 4.1 R in DAG number 2562 as per order passed by the circle officer dated 3/9/1990 in sale possession case number 252 of 1989-90 is granted along with other particulars. This was regular mutation, my lord, office mutation. Signature so-and-so. Now go kindly see. As per order of the circle officer dated 10/12/13, this was in 13, in sale possession case number 337 of 2013-14, mutation is granted to Srimati Hemaprabha Hoikya, wife of late Taranath Hoikya, along with other particulars in DAG number
Mr. Monto, the last office note says that service is not complete.
Service, is it so, my instruction is that it was complete, but they are not appearing.
No, neither ID card, unserved notice received back for respondables 1 to 3 and 5 to 9. That is the last noting, 19/6.
Can you see, my lord, 26 to 24?
26?
2. Order dated 26/2.
Order.
Office note dated 13 to 24 has been referred to, shows that the notice upon the respondent is complete by usual process.
13 to 2024. 13 to 2024.
Usual notice has been accepted by respondent number 1 on behalf of 2 to 9. They are all residents of the same family, same place, same house.
Registered step 4, R4 unserved notice received back with postal note always closed, kept in part 2. 1, 2, 3, 5 to 9, neither ready nor answer. Flag X. Part 2 file আছে না? Part 2 file. Flag X. Usual process has been, first respondent has taken on behalf of all the respondents.
The usual.
I think we'll wait for, give another opportunity because we may be inclined to allow this.
It's always better, my lord.
Yes, if we are
They are
inclined to
present.
allow this, if we are dismissing, then probably we would have not. But if we allow this,
Yes.
let us give them a chance. You are having an interim order, I think?
Yes.
Okay, we'll extend it.
Only thing is, well, they are by the side of my pen, they are trying to somehow occupy it. That is the anxiety of our physical person they want to forcefully.
Under what strength of what?
Sorry.
They're trying to dispose you on the strength of what? Illegally?
Yes, the soldiers they have filed, they said that no sale was done.
That is okay. They have to be armed with a decree first.
True, well, they are not doing it.
They cannot illegally. That for that this
That-
will not help.
That they have not asked for injunction also. I don't know, but then they take the advantage of by being nearer to the back. Possibly fix it after vacation.
We'll fix a date. Let
Yes.
us have a heard Sri K.K. Mahantolanet Senior Counsel for the petitioner. Full stop. This court wide order dated 26/2/2024 had taken note of the had recorded the office note dated 13/2/2024 regarding service of notice upon the respondents by usual process, which was found to be complete. Full stop. The steps taken by registered post AD and the report on the steps taken by registered post with AD is, however, inconclusive as per office note dated 19/6/2024. Para. In the interest of justice, matter is adjourned to be listed on 19th of July. Is it okay? 19th of July, 2024. Full stop. The interim order passed earlier to continue till the next date of listing.
Yep.
Wait, please, just a lot.
Yes, 16.
This is a matrimonial appeal.
come up for the first time?
My lord. The
Or
appellant-
Hard 3 HP Gwala Learned Council or the appellant who has referred this appeal. Why are you invoking in section 19?
I find primary in the judgment matter.
If you invoke 19, it will go before a DB. And it is by a district judge, not by a family court. Don't invoke provisions of a law which is not applicable in your proceeding. Your proceeding was under the Hindu Marriage Act, not under the Family Courts Act. You should structure your petition properly. The council, what is this?
28 also there.
Also will not be, it has to be only under 28. Appeal, provision eligible, appeal against the you said again order. Why do you write order? Is it an order? It's a final judgment.
Judgment, my.
Why do you write order? Against the judgment dated 29/5/2024 by which the suit instituted by the appellant for divorce under section 13(1)(1) of the Hindu Marriage Act has been rejected, has been dismissed. Full stop. Para. Admit. Para call for the records. Let steps for service of notice upon the sole respondent be taken in usual process as well as by registered post with AD. Full stop. The steps by registered post are to be taken in both the addresses. List after 6 weeks along with service report.
Obliged.
Call for record করেছে না?
But in this case, the insurance company, let's say appellant,
First time,
had adduced evidence to prove that.
first time it has come.
It is filed, first time it's for admission.
I am for my lord responding to one.
We'll admit this.
Yes, sir.
We'll admit this. What are your grounds? What
But there's no, this vehicle was not insured by the insurance company, they had adduced evidence, but in the judgment, it was written that insurance company did not adduce any evidence. I have adduced, I have, in fact,
Mr.
enclosed a
Bhuyan?
copy of the
I am for respondent 1 to 5.
claimant.
What do you say?
Claimant. So, appeal memo, I have not. Appeal.
Okay.
File.
Heard Sri R. Goswami Learned Council for the appellant who has preferred this appeal under section 173 of the Motor Vehicles Act against so and so, huh? Judgment it is saleable. So it is submitted that the appellant was not connected with the vehicle in question, and in spite of adducing evidence to that effect, comma, the impugned judgment has recorded that no evidence
Yeah.
was adduced by the appellant. Full stop. Para. Admit. Call for the records. Mr. Bhuyan for
I am for 1 to 5. Claimant.
3 K. Bhuyan, Learned Council, has entered appearance and accepts notice on behalf of respondent numbers 1 to 5. Para, let extra copy of the memo of appeal along with the enclosures be served upon him.
I have already given.
Let steps be taken for service of notice upon the respondent 6 and 7 by usual process.
Lordship, 6 and 7, Lordship, the justice was taken. That is still awaited. If not,
In
there
this
is-
appeal,
Yes, sir, in this-
no, the appeal has come for the first time.
No, Lordship, no, there's a delay, it was filed in 2016.
Understood, delay was condoned. Now
Delay
in
is
the
con-
appeal, you have to take
Which
steps,
case?
usual process.
No, that justice is still awaited, Lordship, because in spite of the justice.
In which case?
So, Lordship, if that doesn't
I-
come, I'll come before the court and ask for a paper publication.
Now, first you take steps by usual process. That miscase has culminated by their final orders, condoning the delay. Okay, you take usual process. If it is not able to serve, then you will go for paper publication.
Yes.
List of the six along with service report, along with service report, along with report on service.
Problem.
LCR also.
We'll call for LCR.
Hello.
You don't have any interim prayer for
No, no,
stay?
there's a prayer for stay, Lord. Say that without any deposit.
Huh?
Without deposit.
We have to remind you to press
No, no,
your
no,
stay
I-
prayer.
That is fine. Because we are suffering, my lord, because they are claiming. What committed by mistake by the third telco. We are free to that.
No, if it is, if,
Whether
if,
it's fair
if
or-
this insurance company is not at all connected, how do you settle them?
Because
It's not a case that some amount has,
Owner will respond.
owner will be responsible. That's a different matter.
If insurance not covered, then owner will.
And nowadays, pay and recovery is also not there. Where is your IA?
I work for condonation.
No, I was for condonation, that was on stage also there, 1615.
Huh? 1615, huh? Heard Sri R. Goswami, learned counsel for the applicant, who by means of this application has prayed for stay of the judgment and order dated so and so passed by so and so. The connected appeal, MSC, appeal number 237 of 2024 has been admitted today. Full stop. Para. The learned counsel has submitted that the insurance company, the applicant insurance company is not at all connected with the accident and the vehicle involved. And in spite of adducing evidence, the learned tribunal has come to a finding that no such evidence was adduced. Full stop. Para. Considering the above, you'd like to file objection, let notice be issued in this petition. Sri K. Bhuya, learned counsel, has appeared and accepted notice on behalf of respondents 1 to 5. Let steps be taken for service of notice upon the respondent number 6 and 7 by registered post as well as usual process. Para. Till the returnable date, however, the impugned judgment would remain stayed qua the applicant appellant. Full stop. The aforesaid interim order would however be reconsidered upon filing of objection. We are not disposing this of, it will remain.
Lordship, it's an statutory appeal, Lordship. The ground of appeal is, Lordship, the claimant is a married sister of victim, Lordship, and he is admittedly having her own income. So as far as Sarla Burman, Lordship, he is not entitled to amount in the loss of dividend.
There is
And
no
our-
dependency factor.
Yes, Lordship, and our driving license was also not valid. Which
How much is the amount?
10 lakhs, Lordship.
10,32,600. Lordship, as per the dependency, recently Guwahati High Court in Pandikanta Das has stated even married brother are entitled to loss of estate, Lordship, along with other conventional.
But dependency, loss of estate is a different head. Dependency. Where you dependent on the income of the deceased?
Lordship, I'm the only living heir of the.
No, so you'll be you may be getting other compensation under the other heads. But this is a head of dependency that you are dependent on the deceased. And on his passing away, your life has become critical now. No, that is not the factor. 10 lakhs have been granted.
lakh
Okay, I will
42,000.
do something. Okay. Heard Sri A.J. Sekia, Learned Counsel for the appellant insurance company who has preferred this appeal under section 173 of the Motor Vehicles Act against so and so. Also, it is submitted that the claimant, being the married sister of the deceased, was not dependent on the deceased, and therefore the award on the dependency factor is unsustainable. Full stop. So Sekia has also highlighted the aspect of lack of proper driving license. Full stop. Para. Admit. Call for the records. Yes, your name?
Mr. Enik,
Anikbal.
Enik,
Anikbal. For whom?
for respondent one claimant.
One. Okay. Sri Anikbal, Learned Counsel. Appears and accepts notice on behalf of respondent number 1, claimant. Who's 2?
2 and 3 lordship, owner and driver. In the delay petition, they refuse to take.
You have to take, let steps be taken for service of notice upon respondent numbers 2 and 3 by registered post with by usual process as well as by registered post with AD. Steps within 3 working days. List after 6 weeks along with report on service.
The petition is there.
Heard 3 A.J. Sekia, Learned Counsel for the appellant who by means of this application has paid for stay of the so-and-so, caused by so-and-so. Full stop. It is submitted that the claimant is the married sister of the deceased and there was no dependency. Full stop. Para. After hearing, comma, the impugned judgment and order dated so-and-so passed by so-and-so is stayed subject to deposit of 30% of the award before this court, before in the registry of this court. Are you will be appearing? 3 Learned Counsel submits that he may be that the that the opposite party number 1 may be allowed to withdraw the aforesaid amount. Put the para. The aforesaid prayer would be considered as and when the deposit is made. 30% Kurisa, 30.
May it please, Your
Yes,
Lordship.
yes.
Your Lordship, in this matter, the offending vehicle was tied without there being any registration certificate and road permit. And Your Lordship, under such circumstances, the learned member ought to have passed an award of pay and recovery. That's the main ground in this.
Pay and recovery is still available now.
Yes, Your Lordship. But I don't have the right now. Your Lordship, we
Yes,
also
Mr. Barua.
I am appearing for respondent, claimant 1 and 2.
Okay, we'll admit this. Heard. Sri S. Datta, Learned Counsel for the appellant who has referred this appeal under section 173 of the so-and-so, 170 of the Motor Vehicles Act 1988 against the judgment and award dated April Silava, cross-title. Full stop. It is submitted that the offending vehicle did not have a registration number.
registration certificate, Your Lordship, and road permit.
What is the registration certificate?
Your Lordship, the RC of the vehicle.
New vehicle.
Registration number, registration certificate, as well as road permit. Road permit.
Yes.
And who it was insured with you?
Yes.
Yes, your lordship.
Then how does it make a difference?
Your lordship, we pressed this ground in the,
No, there has to be a violation of policy conditions.
yes,
That
your
is the
lordship.
only defense you will get.
Yes,
What policy conditions were violated?
there was no, this, registration
Registration is a
certificate and
new vehicle. Why did you insure if there is no vehicle number? At the time of taking premium, you are very open. At the time of giving, no. Why?
your lordship, at this stage, we are ready to deposit 50%.
That was not the
amount
intention.
we
That was
issued.
not the intention of the court to coerce you to deposit. Okay. क्यों लिख लो सर? Did not have a registration certificate as well as road permit. For the para admit. Call for the records. Sri B. Barua Learned Council appears and accepts notice on behalf of respondent numbers
1 and 2.
1 and 2, the claimants.
Yes.
Mr. Roy?
3.
3, who's driver? And 4?
Four is the owner, your lordship.
SS Roy. Learned Council accepts notice on behalf of respondent number 3. Let extra copies of the memo of appeal along with enclosures be served upon the Learned Council for the respondents. Para, let steps be taken for service of notice upon the respondent number 4 by registered post with AD as well as usual process. Steps within 3 working days. How much has been granted?
4,80,000.
Or injury case?
Death
Death case. What was the deceased doing?
He was
Helper of the vehicle.
Huh?
helper of the vehicle.
Helper, age
37 years.
37.
only 4,80,000. And you are appealing. Heard. S. Dr. Learned Council for the applicant appellant who by means of this application has prayed for stay of the judgment and ordered dated so and so, huh? Passed by so and so. Appeal to the evidence. That's what it is submitted. That there were violations of the policy conditions in as much as the offending vehicle did not have a registration certificate or a road permit. What's the para? Considering the same, comma, the impugned judgment and order dated so and so passed by so and so is stayed pending till disposal of the connected appeal, subject to deposit of 50% of the awarded amount in the registry of this court.
My lord, liberty may also be defended.
The respondent was 1 and 2. The opposite person of 1 and 2 claimants may make appropriate prayer after deposit of the amount in the registry for release. Yes.
Yeah, look, the petitioner has challenged the order dated 31 at annexure 6, whereby the amendment application has been partly allowed.
EOD,
I have a plaintiff.
petitioner is the plaintiff.
Plaintiff.
Suit for?
Suit for partition, declaration and partition.
Then?
Here is some background. Initially, the petitioner number was as the sole plaintiff filed a suit in the year 2019, arraying the respondents herein as main defendant and the petitioner number 2 and 3 as pro forma defendant number 1 and 2. And his sister as pro forma. So, after receiving summons, the defendant, the main defendant, respondent number 1 and 2, contested the suit by filing their common written statement counterclaim. So thereafter, the pro forma defendant number 1 and 2, that is the petitioner 2 and 3 herein, file an application for transporting them as the plaintiff, which was allowed by the learned court below. So after that, while allowing this transposition application, the learned court below directed the plaintiff to file a joint plaint and or a amended plaint. Accordingly, they have filed joint plaint, and on the same date, they have also filed an application for amendment of pleading, stating that in the written statement, they have respondent defendants have took a ground that apart from the Schedule A to G properties, there are 2 more properties which has been left out by the plaintiff, and accordingly to incorporate the 2 properties, they have filed an amendment application, and in respect of Schedule F and G properties, the plaintiff number 1 has sold a portion of the land. So to reduce that portion from his share from that properties, and to impede those purchasers who has purchased that plot of land from the plaintiff number 1. So a composite application has been filed under orders to Rule 17 and Order 1 Rule 10. So that was so far adding the parties and amendment of pleading has been allowed, but the prayer for inclusion of 2 properties in the prayer number A has been rejected, stating that is bad under Article 58 of the Limitation Act. That relevant portion at page 70. That is not correct. 52 is not applicable in respect of joint property. 72 is the operative finding.
$72.
72, second paragraph. Married.
Yes.
Now, second paragraph. Now the matter which has come to the knowledge of this court require to be looked through Order 6, Rule 70, Digit 151 CPC. It can be observed by this court that the defendant has stated that they have mentioned about the land in Patta number 42 and Patta number 6 and contention that since the plaintiff failed to bring the same fact in their former amendment, that is wrong. There is no former amendment. And so their same may be not to be allowed. Now it is observed by this court that the plot of land under Patta number 42 and Patta number 6, Schedule H and I, was not added in the main plain as well as in the previously amended plain. Also, it can be observed that the amendment has been sought for to include Schedule H and I plot of land, hereby also adding a new relief for declaration of right title interest in the suit land, H and I, including the other suit land. Now it is perceived by this court that regarding adding of a new relief, the period of limitation must be taken into consideration. In this regard, the Honorable Supreme Court in so has held that the amendment of pleading to add a new relief, if it is barred by limitation, would not be allowed. The new relief so prayed for adding will come under the purview of Article.
Mr. Dekha, today is for admission.
Yes, sir.
Can we dispose this of an admission stage?
Small issue, Lord.
Short matter. Only ground of repetition. Your lordship, this cause of action has been put by the Learned Court to at page 73, 111, 111,000. After not and so my only.
How was the calculation done then?
The date of cause of action with the date on which. So this was filed on March 2000. And
not March 2020.
2020.
So 3 years also not left.
So matter my only submission that after good for action
you automatically get
No, you will get the time prescribed by law.
Yes, sir. You get the time. That is. Pause testing. Pause is either because this application has been filed at the very initial step. Issue has not been framed.
First, you sort it out with him outside the court.
No, not me, madam. In the impure order.
Today is Friday.
Yes.
Permitted.
Not he's contesting election. He has to think.
then he'll pay the cost. What elections? Lok Sabha?
No, the bar election.
Lok Sabha is to wait till 5 years. Chance gone this time. Okay, heard disposal. Heard Sri S. Jaka, Learned Counsel for the petitioners who by means of this application filed under Article 227 of the Constitution of India has put to challenge an order dated 31/8/2023 passed by the learned civil judge, Junior Division Bozali, in Miss J case number 115 of 2021 arising out of title suit 17 of 2021, full stop. By the aforesaid order, comma, the learned court, while allowing the prayer for amendment of pleadings and for implement of new parties, has rejected has rejected the prayer for amendment of inclusion of new fresh relief oblique prayer, full stop. Para 3 Deca, the the petitioners were the plaintiffs in the aforesaid suit, which was initially instituted in the year 2019 by the petitioner number 1 alone, in which the petitioners numbers 2 and 3 were made the pro forma defendant. Full stop. The suit was for declaration and partition. Full stop. Subsequently, the pro forma petitioners subsequently the petition numbers 2 and 3 herein had filed an application for their transposition from pro forma defendant to plaintiffs, which was accordingly allowed. Full stop. As a result thereof, comma, application was filed for amending the plaint and also to include certain other properties. Full stop. The learned court, by the aforesaid, has, however, passed the aforesaid order dated 31/8/2023, whereby there has been rejection of part of the prayers made. Full stop. Para 3 Deca, the learned counsel for the petitioners, has submitted that the reasons assigned for such rejection by bringing in the aspect of limitation is not in accordance with law. Full stop. It is submitted that the limitation has to be calculated from the date of institution of the original suit and from which the cause of action had arisen. Full stop. He accordingly submits that interference by this court is required with regard to the impugned order dated 31/8/2023. Full stop. Para 3 P. Bharadwaj, learned counsel for the respondents.
Yes.
Two respondents.
Yes.
Has, however, submitted that the impugned order does not suffer from such legal infirmities which would require interference by this court under Article 227, which is only a supervisory jurisdiction. Full stop. He has submitted that the impugned order contains reasons which are plausible and are not required to be substituted. Full stop. The learned counsel has, however, fairly submitted that the aspect of limitation may not have been properly appreciated by the learned court. Full stop. Para. The rival submissions have been considered and the impugned order has been examined. Full stop. This court has noticed that after the transposition of the pro forma defendant of the original suit as plaintiffs, comma, there was a requirement of amendment of the plaint, which was accordingly done. Full stop. In the considered opinion of this court, comma, the learned court, while allowing such amendment, should not have restricted the prayers sought to have been made, more so when the contesting defendants would have all the rights to contest such prayers in accordance with law. Full stop. The application of the law of limitation also does not appear to be in its proper perspective. Full stop. Para. In view of the above, comma, the present application is allowed and the impugned order dated 31/8/2023 passed by so and so is stands modified by with a direction that the amendments sought for by the petitioners as plaintiffs are to be allowed in its entirety. Full stop. It is needless to state that the defendants would be at liberty to file their written statement in accordance with law.
Apply. Interim order passed.
Interim order passed earlier stands vacated, stands merged with the final order.
Date may be fixed for appearance of
The parties are accordingly directed to appear before the learned court below on 19th, on 17th, on 16th of July, 2020. Or should I give it early?
Because we have to file amended plain.
No, is there any vacation there?
No.
Today is 21st. Okay, no problem. On 15th of July. 15th of July, 2024. From which date the learned court would take charge of the proceedings.
Apply.
Okay.
An application for an appeal for enhancement of the award. There are some typographical error, Lordship. A week time may be granted for making
Error in where?
in the memo of appeal, Lordship.
Mhm.
Is wrongly typed.
It's to 14 matter. What kind of error?
Lordship, the case in the cost title is all, but in before the grounds, the case number and entire paragraph is wrong.
We can ignore it, perhaps. Depends on you. If substantially there is nothing wrong, so we can
There
proceed.
is nothing wrong because
We
in
can-
cost title and the
We can record that in the judgment that this will not affect your, if you have otherwise make out a case.
then Lordship,
We would have allowed, but this is a matter of more than a decade old.
Yes.
So for those purpose, we don't like to delay the matter.
Lordship, then it may be fixed for hearing.
Okay. this matter has been listed. You were given time in 19, Mr. Datta. Why
Yes, Lordship,
do
but after they are.
5 years have passed?
Yes, Lordship, this is
You have not
thereafter,
even given the typographical.
Lordship, thereafter COVID has come and declined this.
COVID came, COVID went, COVID is history
Yes,
now.
Lordship.
Every day there is
It
COVID.
is gone out of our mind, Lordship. In fact, decades is.
Tomorrow something else is going to come. Again, you'll have time.
Because the client
No,
is.
you don't, you rectify the mistake. We thought this was the first time you are making a submission. The order dated 28/11/2019 passed by this court reflects that on the prayer made on behalf of prayer made by Sri U. Datta, Learned Counsel for the appellant, 10 days time was granted to take steps to rectify. Full stop. However, till now, the steps for rectification have not been taken. Full stop. Sri Datta prays for some more time. Para. As an exceptional circumstances, a week's time is given as a final opportunity to rectify the mistakes, failing which this court would proceed in accordance with law. List immediately after the vacations.
Can it be 31st of July?
We say immediately after the vacation. Are you there or not? Not there.
Then after 1 week.
1 week, so it will not be possible. Next week, vacations will be there. I don't say any detail. List immediate list after the vacations.
Must apply.
No, that will be immediately after the vacations. If you want time, we will give you time.
Okay.
We are giving 7 days time to Mr. Datta. List immediately after the vacations. Yes, next.
Right. As per office note dated 19/6/24, respondent number 125 file Wakalatnama for six Lordship, report not yet received and LCR received. So we have to, I think, wait for six Lordship and then it can go for final.
1 to 5. Tarudha,
I'm
preparing.
1 to 4.
5.
Abhi to owner.
1 to 4.
Has not been received.
5 is the owner. That
LCR has
also
been-
sub Lordship.
Who's 6?
6 is the driver.
Is necessary.
Actually, not necessary because we are saying that he did not die due to the accident. So that fraud involved. In fact, driver is not so necessary.
You take another opportunity, take fresh steps. These steps were taken in 2022.
Kachar. Lordship can be taken in Dusty because
it-
that is easier for.
Okay, you take Dusty. Miss R.D. Mazumdar, Learned Counsel for the appellant, where Sri M. Talukdar is present for respond numbers
1 to 4.
1 to 4. Full stop para. Office note dated 19/6/2024 reflects that respond numbers 1, TO2, 5 are represented by counsel. Full stop. However, the AD card, however, the report of service upon respond number 6 is not complete. Full stop para. On request by Ms. Mazumdar, Learned Counsel, liberty is granted for causing dusty service upon the respond number 6. That's what I can rotate through the registry or notice or date, affidavit prior to the next date. Fix the next date as
In August, maybe Lordship.
on 29th of July. You have to file affidavit.
Yes, sir.
Right. And take the notice to early next week itself, otherwise it'll be difficult.
Yes, sir. Okay.
22.
My lord, I am appearing for respondent number 3, my lord, insurance matter.
Who's for the appellant? J. Sharma B. Das. Who is J. Sharma B. Das? By order, who has got by order? Who has mentioned this matter?
think service is not complete.
This matter has been listed by order
Yes.
on behalf of the appellant who had filed a mentioned memo. Also, however, when the matter is called upon, there is no representation on behalf of the appellant, in spite of names of the council being reflected in the cause list. Full stop. Miss S. Sharma, L. Sharma, learned counsel is present for the respond number?
3.
3. Full stop para. List after 4 weeks.
Obligatory. My lord, kindly peruse the office note dated 18/6/24, my in MS item number 23, my lord.
Office note.
Dated 18/6/24, my lord. 1, 2, and 3 appeared, my lord. And 4, 5, 6 service may be awaited, my lord. But in item number 24, my lord.
Both are connected.
Yes, my lord. In
You are appearing for
Respondent 1 and 2. My lord,
1
claimant
and 2.
And in item number 24, 1, 2, 3, 4, and 6 appeared, my already served, my lord, will be served. We have to take only steps on respond number 5, my lord. In item number 24.
You are for 3.
No, my lord, I responded 1 and 2, the claimant 1.
Now, which one? 739.
Yes, sir, in both these cases.
In both
I have
cases, my lord.
responded 1 and the claimant.
Why 2 appeals?
My lord, they have no, the driver of the vehicle did not having a valid insurance policy at the time of accident, my lord. And we have not taken plea in this memo of appeal. That's why, my lord, we have to file affidavit. Last order was, my
No,
lord.
no, why 2 appeals?
2 appeals, my lord.
2 MS cases where there are 2 digits, my lord, that is the wife and son died accident. 2 separate MSC cases where
Okay, there are 2.
and
Okay,
also-
okay. The claimants are the same.
Yes, my
Yes,
lord.
ma'am.
Oh, the son as well as husband had died.
Yes, my lord.
Wife,
Wife.
the claimant is husband and daughter.
Okay,
The
okay, okay.
wife and
One is for the
and
death of
only
the.
son died.
Okay,
That's
okay.
it.
And it's a common judgment.
Yes, my
2
lord.
separate judgment was passed. Trial was analogous trial.
That is separate judgments. Okay.
Separate
You are for 1 and 2
1 and
in both the appeals.
in both.
And the others, madam?
My lord, 3 appeared, my lord, already, and in item number 24, only 5, respondent number 5.
Who is for 3? D.
Uh,
Barua, D. Barua. Who is D. Barua? D. Barua, PC. Bornali Nayar.
Konali Nair is the claimant.
Okay, your colleague. And T. Pait, R3.
Yes, my lord. They are representing, my lord, respondent number
3.
3, my. Devojit Kodwar.
In both the matters.
In
Yes.
both these cases, my
Yes, my lord.
respondent 3 is the reception, the registered owner of the offending
Madam,
vehicle.
what do you want?
My lord, we have to take again, my lord, correct
For?
address,
For?
for respondent number 5.
In both the cases.
Yes, my lord, in await service in item number 23, on respondent number 4, 5, and 6, my lord.
23, 7,
18, 6, 20.
My lord, in one appeal, the 4, 5, 6
3 is reflected there, my lord.
awaited,
No.
and in another appeal, my lord, only respondent 5 is awaited.
You write separately, okay? In 739 of 2022, the pehla item hai.
No, be recalled.
Heard Miss L. Sharma, learned counsel for the appellant. Full stop. Your SK Jain, BK Jain, Sri BK Jain, learned counsel, is present for the respond numbers 1 and 2.
1 and both.
1 and 2. The name of the learned counsel for the respond number 3 also appears in the cause list, who however He is not present when the matter is called upon. Full stop, para. Office note dated 21, 20. No.
24.
No.
18/6/24. In both
Three
the cases.
has already appeared.
My lord, in
18/6/2024 has. Say 18/6/24
3, 4 and
reflects that AD card of respondents 3 to respondent 6 have not been received back. Full stop. As noted above, respondent 3 has already entered appearance. Full stop. Learned counsel for the appellant is accordingly directed to take fresh steps on the respondents 4, 5, and 6 by registered post with AD. Let steps be taken.
Dusty service.
You want Dusty?
Yes, my lord, all are
Okay.
from Guwahati, my lord. From Guwahati.
4, 5, and 6 by Dusty service, routed through the court. Notice my date. Affidavit prior to the next date, changes. There, let the next date be fixed on.
Okay.
We'll have it on 26th of July. You have to file an affidavit prior to 26. Prior to the next date. Affidavit, 3 चीज होगा. Routed through court, notice my date, and prior to the next date.
Has already been admitted.
Which one?
Both these appeals.
Yes.
Delay contra appeal.
No, we have seen that.
In one, my lord, the petition is pending, my lord.
After my lord receiving the, they may appear, my lord. All the parties, my lord.
My lord,
You can go for execution if they are not pressing for stay.
my lord,
Earlier, my lord, we have,
there were two appeals, my lord. In one appeal, my lord, already is granted, subject to deposit of 50%. And in another appeal, my lord, they have prayed before this honorable court that they will have not taken any plea for regarding driving license, abatement of driving license. This court was pleased to allow them to file an affidavit and directing them to file within 4 weeks, man. Now it is 80 weeks, man. Till
My
date, they did
my
not
lord,
file the
some time is
affidavit, ma'am.
needed. Because
And
my
there in the
unavoidable
in the district court-
circumstances is there, my
Jain,
lord.
unless they press for stay, the question of
Yes.
deposit may not come. You go for
Yes.
execution. The moment they come for stay, we'll direct 50% deposit.
But we had already filed the Bhakti proceeding initiated, but there they have filed a petition.
In
that
the
this
meantime, my lord,
is
some time
pending
may be granted
adjudication.
to file
What
affidavit, my
what
lord.
is the law that in absence of any stay, there will be stay of Baki Jai? You impress upon them, there is no stay. Let them produce a stay order. Madam, why don't you deposit some amount?
My lord, we have to file affidavit, my lord, in this regard, my lord.
But for that, you are causing delay.
In
we-
one case, we have already deposited.
Now we grind. That is that different. 2 persons have died.
Yes.
One case you have deposited. That's not an excuse.
It
These
is
are
open not 9 years back, ma'am. What can-
that case. You take instructions, madam.
Yes.
Next. And then the next second one, what order?
Second was, my lord,
572.
uh,
Here for 1 and 2. Same 3 is also
Same.
appearing. And 4 and 5, 4, 5, 6.
only we have to take service of notice on respondent number 5 only, my
And 4 and 6.
lord. 3, 4 and 5 duly served, my lord. 18/6/24, my lord. Already.
3 has also appeared, I
order is
think.
there, my
3 has appeared or not, Mr. Jain, in this case?
3 has
lord.
appeared, my lord.
Name is reflected there, my lord.
My lord, office note reflect, my lord, in another appeal, my lord, 572. Here only notice on respondent 5 could not be served only. Rest are services completed.
LS, 3, duly represent 3. 4 received by sister.
Office noted 18/6/24.
Duly served. Okay. In terms of the heard, Miss Al Sharma, learned counsel for the appellant, whereas BK Jain, learned counsel, is present for the respondables, 1 and 2 claimants. Full stop. The respondable, the name of the counsel of the respondable 3 is also reflected in the cause list.
Yes.
Who, however, is not present. Full stop. Para. In terms of the office note dated 18/6/2024, whereby the respondent number 5 is yet to be served, comma, learned counsel for the appellant prays for and is given liberty to serve Dusty. Same, huh? Take dusty notice and file affidavit. Next date same.
Obliged will.
26th. 26. Madam, 26 is the next date. 26th of July. File affidavit before that.
Obliged
Okay.
will.
Records have come?
Yes, ma'am. Healthcare had already.
Okay.
Regarding service, my lord, by office note dated 56/24.
Yes.
Found that, my lord, service to respondent number 1 to 5 has been deemed to be served, my lord. As per the Lodgement Code order dated 11/6/24.
Where is the order dated 11/6/2024 of the learned Lodgima Court? Full stop. Service upon the respondent numbers 1 to 5 is held to be complete. Full stop.
And others 6 to 12 has been completed by Justice Service earlier.
Earlier.
Earlier, by order
It's okay,
dated 12, 10, 20.
List for admission immediately after the vacation.
Yes. A date may be given because, my lord, regarding status quo matter is there, my lord, only. Small
List for
matter.
admission on 19th of July.
Obliged.
Immediately after vacation, mat likhiye 19th. Yes, madam. What is this?
May I please proceed?
Yes, notice was issued, Mr. Dhar, your appearance.
I'm appearing. I have filed my petition.
It has come on record.
Yes, ma'am.
Yes.
Okay, we need some time to file our
File reply. What is this matter? Why are you filing affidavit in opposition, Mr.
My
Dhar?
lord, there is
CRP.
some separation, my lord, and they have not
Okay.
annexed.
On the prayer of Madam, your name?
C.
C. Rekha, Learned Counsel for the petitioner. 3 weeks' time is granted to file rejoinder affidavit.
My lord, my suit is has been stayed.
Fix on, tell us a date.
Any day on the month.
Fix on
July.
17th of July.
Apply.
Is it okay, 17th of July, madam?
Okay, okay.
17th
Apply.
of July. There is an interim order or what? Madam, who will press the interim order? Interim order passed earlier to continue till the next date of listing.
It is the first. This I is for confirmation of detail.
First time.
No, lordship. Notice already served, lordship. Justice service also, lordship. I have filed affidavit. Refused to accept, lordship. Land grabbing proceeding. Against the same respondent, another land grabbing proceeding was there that was challenged before this High Court, and High Court did their land grabbing.
But as per the usual office note, they could not be traced out.
But lordship, I have filed my justice service affidavit, refused to accept page 35 of my affidavit. And title suit is going on in between both the parties. Before the executing court also, we have filed petitions that we have already challenged this before.
Which date did you go?
Lordship,
Which date did you go?
lordship, that two advocates signed the notice, lordship, page 36 and accept.
No, madam, that is not enough. In paragraph 3, you have to say the which date, where have you gone?
That I have not meant.
You have to say that.
Or your lordship, I may be allowed to serve Dusty Service, among the engaged advocate who is presenting him before the executive court.
This
Or-
affidavit we would have accepted this affidavit. See, there are two reasons why you're again looking into this affidavit. In the usual process, they have said that it's not there, they are not there in the address given. So once you've given the affidavit regarding Dusty, we have to examine it properly. You have not even said which date, where have you gone,
That I have not lordship stated
in his residence or his office, which date, what time.
Here I have only mentioned that the applicant fact to state that he approached the sole opposite party along with the following
When?
advocate. That date I have not. mentioned,
Aren't
but
you
when-
required to, because these are all personal information. These are not based on any documents. Because had it been a matter of acceptance, matter is different. Here
Then I
you
may
said
be
that
allowed to take press step through registered editor.
registered AD.
Or-
Okay. Uh, with regard to the issue of service upon the respondent number 5.
Only one respondent, lordship. Raisul Islam Azad, page 2, lordship.
Respondent number?
Only
Sole respondent,
Sole
comma. Learned counsel Miss R. Chaudhary. Brace for and is granted liberty to serve notice by registered post with AD. Full stop. Let steps accordingly be taken for such service by registered post with AD within 3 working days. List after 6 weeks along with service report.
There earlier, in earlier petition also, I have served the same address, lordship. Raisul Islam Azad, son of Abdul Hamid,
Okay, in registered AD you might have some luck.
lordship. Obliged.
Okay.
May please be Mr. Lordship, as per official date 12/6/24, Lordship, I was allowed to reconstruct the file, but I want some more time for reconstruct.
Some records went missing.
Yes, Lord.
5 numbers of records.
Yes, Lord. But from the registry, Lordship, misplaced something.
What has happened to the police case? One FIR was lodged.
Not, Lord.
Hmm?
Not, Lord.
5 numbers of court case missing.
Yes, Lord, for the registry. And there were
Do wide order dated 15/5/2024. The Learned Counsel for the appellant Sri A.R. Agarwala was directed to take steps for reconstruction of the records, comma. The Learned Counsel has prayed for some more time for the said purpose. Para, list after the summer vacations.
6 weeks, Lord.
After the summer vacation, it'll be 6 weeks.
Lordship, summer vacation, I'll not be able to. After 6 weeks.
Why 6 weeks? Records when missing when? In August 2023, more than a year now.
Lordship, for request for summer vacation.
After 4 weeks.
And after summer vacation, Lord.
After 4 weeks, after 4 weeks is summer vacation. Other matters? Other matters? Mr. Agarwala, you have other matters. What are the other matters? All same. There is not one matter.
Other matter was there for 42, Lordship.
You need time for reconstruction.
Oh, all the request.
Oh, same.
Same.
Okay. Huh? Yes.
Other matter.
Okay. Next. I don't get it.
After publication, paper publication, we have filed a recorded affidavit.
You have filed affidavit?
Affidavit.
But the office, like
When did you file affidavit?
25, no affidavit.
Affidavit to go.
Office note is saying something.
It was filed on 6/6/2024. Affidavit to go.
Along with the paper?
Yes.
Though office note dated 25/2024 reflects that no affidavit has been filed with regard to service of notice upon the respondent number 1 by paper publication, comma, Sri U. Datta, Learned Counsel for the applicants has submitted that such affidavit was filed on
6/6/2024.
6/6/2024. This is a notice of 25.
Yes, Lordship.
He just filed 6/6.
Maybe
Office
after
to
that they have not put any
office to
note.
verify and tag the said affidavit along with the case records and list this case immediately thereafter.
Obliged.
May I please your lord?
Lordship, there is a delay of 71 days in preferring the connected appeal, and I have challenged only the quantum. You're the claimant. Claimant. And you want announcement? Yes. And my learned friend is. You filed your objection.
No, your lord, we have no objection.
How many days? 71. Heard Sri D. Mondal, learned counsel, for the applicant who by means of this application has prayed for condonation of delay of 71 days in preferring the appeal against the judgment and award dated so and so 19/10/2022 passed by so and so, हाँ? इसमें देख लीजिए, हाँ, फर्स्ट पैराग्राफ में. The learned counsel has submitted, and the learned counsel for the applicant, comma, by referring to the averments made in paragraph 12, paragraph 2 of the petition, has submitted that there were sufficient grounds for which the applicant was prevented from filing the appeal within the prescribed period of limitation. Full stop. Amongst the grounds cited, comma, it is submitted that the applicant had some medical issues
Disabled.
due to weakness of his right leg. Full stop. Para. Also heard Sri S. Datta, learned counsel for the respondent
two, your
insurance company. Respondent
Yes,
number?
your lord. Respondent number 2, your lord.
To insurance company.
Yes.
Who submits that on principle he may not have a serious objection. Full stop. However, he submits that he has serious issues with regard to the prayer made in the appeal for enhancement, which he would advance at the time of consideration of the appeal. Full stop. Para. Considering the rival submissions and also taking into account the settled law on the aspect of condonation of delay, wherein a justice-oriented and pragmatic approach is required, comma, the delay of 71 days in preferring the appeal is condoned. Full stop. Appeal stands allowed. In the application stands allowed, huh? And in the main appeal you write the IA 1354 of 2023 filed for condonation of delay has been allowed today. That is so and so IA. Appeal to be registered and listed for admission after the vacation, after summer vacation. After the summer vacation. Okay.
Obliged.
You supply a copy to Mr. Datta.
May this is your lordship. Lordship, this is a delay petition. Last time the delay petition could not be taken up at he was not there. Lordship. There is a delay of 334 days, lordship. The delay I have explained at paragraph 3 to
Yes,
8.
yes, what do you say?
11.
My lord, there's been almost 1 year delay here.
Now have you filed objection?
You not file objection.
If you like, you can file objection.
Your lordship will file a.
Let them file objection.
Yes. Because in this case, lordship, the tribunal has asked us to pay to the claimant and then in fact recover it from the claim. Because the driver was driving, he was the owner of the vehicle and his mother filed the claim petition. We proved that the DL was not valid. And the court said that we will pay 1 lakh to him because he, as per the policy condition, and then recover it from the legal heir. He is the legal heir.
Only here.
He is the legal heir.
Okay.
That is the.
Mother is the claimant.
You are Sakya.
Eke Gogoi.
Huh?
Eke Gogoi. My name is not shown there.
Mr. Gogoi, where is your name? You are for R1.
Yeah,
Only one
one
respondent.
Oh, okay. On the prayer of Sri A.K. Gogoi, Learned Counsel for the respondent number 1, matter is adjourned by 4 weeks to enable filing of objection affidavit to this delay condemnation application. Okay.
Highly obliged. May it please your lordship. In this case, lordship, we have preferred this appeal with a limited prayer, lordship. In this case, the learned tribunal did not grant penalty light interest. So in view of the judgment passed by this honorable court, lordship, we are entitled to get the penalty light interest, lordship.
Yes, madam. When?
Lord, matter of fact, here. There has a very small lordship. This may be disposed at this stage. By relying on this judgment.
Who is your senior? B. Chakraborty. He is never here. Last time also it taken time. Okay, we'll grant some time. Okay. When? M. Sharma. Heard Miss M. Sharma, Learned Counsel for the appellant, who submits that the appeal involves a small issue connected with grant of interest, penalty light, and further submits that this issue has been resolved by this court in earlier cases. Full stop. Para. However, a prayer for adjournment has been made on behalf of Sri B. Chakraborty, Learned CGC. Full stop. Para. Considering the above, list on when?
Lordship, kindly, it may be fixed on 16th of
18th,
18th.
Thursday. Finish.
Obliged.
Okay, rest dates. Yes, if there is urgency.
Lordship, actually, this matter, Lordship, here, we were not allowed to file WS. I mean, on the 72nd day with the notice being served, the suit proceeded ex parte. And thereafter, we, for setting aside ex parte, we had filed an application that was rejected, and therefore this civil revision. And Lordship, the petition wherein for setting aside was filed, there the cause was shown, the good cause was shown that the advocate had done a wrong noting in the diary. And that was just the second date. On the first date, the advocate had appeared. He had taken time for filing WS, as is the usual practice. And on the next date, he was absent. On that day itself, it was proceeded expert. So that is.
But the time, extended time for filing written statement was still there.
Extended time, actually, of course, that is exactly, we cannot say, because it can be extended up to 90 days. But then the next date was fixed on the 72nd day.
No, not within 90 days.
Within 90 days.
That is it. We are, 30 plus ultimately 90.
Ultimately 90.
Time prescribed is 30 days. Then it may be extended to 90 days.
Up to 90 days.
You said that it was within the extended period of 90 days.
Yes.
And yet the suit had proceeded ex parte.
Yes.
But you were absent.
On the date we were absent.
Yes, Mr. Kotak.
Summons was received on, as per the record, 28/3/2023. So one date was there due to the absence of the lawyer.
So therefore, on the part of defendants, exactly there was no default. It was the default of the lawyer. And Lordship, I have a order of a coordinate bench on something on similar lines.
Who says what?
Wherein here the lawyer was not well. That was the reason shown. And it was said that it was not fault of the party.
There is only one decision.
Oh, definitely there will be many, but.
Okay. Yes, we allow this. Mr. Bhumik, how are you connected? How are you connected?
Not in.
Not for moral support. Today time has expired. Expiry time. Friday time expires early actually. Some other day. What is the matter? Other side has appeared.
Yes, they have appeared, they have filed objection.
How many days? 250. You're seriously objecting?
Well, there is a short issue that
Seriously objecting or not? Seriously objecting? No, that is okay, but serious objection. Okay.
That is the reason why.
Apart from that, there is a technical issue that needs to be considered by.
May not be possible then. If there was no serious objection, then perhaps outside the time we could have done something. We'll fix it. First, let us pass orders in Mr. Chaudhary's petition. Yes. Item number?
Item 37.
Your MK? MK Chaudhary?
Yes.
Heard Sri MK Chaudhary, Learned Counsel, for the petitioners. Also heard Sri P. Kotoki, Learned Counsel, for the respondents. What's the para? Considering the subject matter, comma, this revision petition is taken up for final disposal at the admission stage. Full stop, para. The petitioners are the defendants in title suit 82 of 2023, which was filed for declaration of right, title and interest, confirmation of position, recovery of khas position, and for permanent injunction. Full stop. The petitioners as defendants had entered appearance and on the next date, however, and the next date, that is 11/7/2023.
24. Next date.
Not 24, 20.
No. Lordship, next date means when we had failed to appear.
Yes.
We had failed to appear on 27/23.
And on the next date fixed, that is 27/2023, comma, the counsel for the petitioners had failed to appear. Full stop. Why the impugned order dated
Page 45, 5 to 24.
5
to 24. Page 45.
5 to 2024. What had happened? Comma. Page?
Page 45.
No. When did it proceed ex parte?
It proceeded ex parte, that Lordship can see at page 51, 27/2022. On the first date of non-appearance. That is page 51.
How do you file order 9 rule 13?
Lordship, that problem is also there.
Order 9, rule 9.
It should be rule 9, yes. The rule is it's actually order wholly.
No, when did it proceed ex parte?
Page 51, the date is 27/2020.
Okay, I mean, क्या लिखा? ना वो ऊपर बोले सुन तो उसके बाद entered appearance and the date for filing written statement was fixed on 26/5/2023, followed by another date, that is 27/2023. Full stop. On the said date, however, due to certain wrong notings of dates, comma, the counsel of the petitioners did not appear and the matter was decided to be proceeded ex parte against the petitioners. And the next date was fixed for ex parte evidence on 14/9/2023.
On 14/9.
14/9/2023. Full stop. The petitioners had accordingly filed an application for setting aside the order to proceed ex parte. Full stop. Para. While the impugned order dated 5/2/2024, comma, the aforesaid application has been rejected and the next date was posted for ex parte evidence of the plaintiff. Full stop. Para. Sri Chaudhary, the learned counsel for the petitioners, has submitted that though as a matter of fact there was non-appearance of the counsel of the petitioners on 27/2023, comma, there were genuine reasons, and in any case, comma, on the same date, comma, the extended period of filing written statement was yet to be over. Full stop. He accordingly submits that the decision to proceed ex parte was not in the interest of justice, as the petitioners' defendants were deprived of their valuable right to defend and contest the suit. Full stop. He also submits that all these grounds were elucidated in the petition filed for vacating ex parte, and by taking a technical approach, comma, the impugned order has been passed dismissing the said application. Full stop. Para. Sri Kotoki, the learned counsel.
They've quoted a wrong provision also.
Sri Kotoki, the learned counsel for the respondent, has, however, by referring to the impugned order dated 5/2/2024, has submitted that the application for vacating ex parte was filed under Order 9, Rule 13 of the CPC, which does not provides for such application to be filed by a defendant. Full stop. A defendant added even during the pendency of the suit. Full stop. He otherwise submits that sufficient time was granted to the defendants, which they, and in the same period, the defendants had failed to submit the written statement. Full stop. Para. This court has noticed that while filing the application for vacating the order to proceed ex parte, comma, the provision of the Code of Civil Procedure, which has been quoted, is Order 9, Rule 13, full stop. Para. It is a settled position of law that quoting of a wrong provision of law or not quoting any provision of law shall not be a reason to discard an application if the said application substantively meets the requirement of law vis-a-vis the relief sought for. Full stop. This court has also noticed that though on 27/2023, comma, there was default on the part of the counsel as well as the petitioners in appearing, comma, certain reasons have been cited regarding wrong noting of dates. Full stop. The petitioners have also cited that what was it? You are suffering. What has happened to you?
Reason, Lordship, because we had engaged the advocate and
No, that and regarding some illness you had said?
no,
Only wrong noting that the Sri Chaudhary has also strenuously contended that recourse to proceeding ex parte on the first date, that too within that too before expiry of the extended period of limitation to file written statement would cause immense hardships and prejudice to his clients. Full stop para. The rival submissions have been duly considered. Full stop para. The decision to proceed ex parte on 27/20/23 was undoubtedly within the extended period of available for filing written statement. Full stop. Though a written statement is ideally to be filed within the prescribed period of limitation of 30 days, the same can be extended up to 90 days. And on 27/20/23, only 72 days, 72 days had expired from the date of receipt of notice, service of notice, full stop. Considering all the aforesaid aspects, this court is of the considered opinion that interest of justice would call for allowing the petitioners to file their written statement in the concerned title suit. Full stop. Accordingly, the impugned order dated 5/2/2024 is set aside, and the defendants and the petitioners, defendants are allowed to file the written statement, which however has to be done within which date?
11/7.
Within
Next date in the trial court is 11/7.
On or before the next date fixed before the trial court, which is said to be 11/7/2024. Full stop. The petitioners are, however, required to pay cost of rupees 5,000 to the plaintiffs as a condition precedent. Full stop. Petition stands allowed. Okay.
Much open.
We'll give a date, Mr. Bhumik. At our early if it yes.
Next. Updated.
Some dates will be given, early date. Yes.
Lordship, my item 43 may kindly be listed as a fixed item, Lordship, otherwise it will never.
It will reach.
Today is a third day, Lordship.
We had done many other matters. Unfortunately, you are left out.
58 to stay today. Same method, so 58, my lord.
We'll have a date.
Interim may be good, my lord.
Is it till today?
Interim.
Is it till today?
Yes. To stay, no argument taken. So, next.
No, is it limited till today?
Today, ma'am.
Item number?
58.
58 में interim extend कर दी.